Before we return to cross-examination of the public staff panel, I will entertain motions from parties regarding testimony of witnesses that have been waived for cross-examination purposes.
Good morning, Chair Mitchell, Christina Krasper-Sigfer. The parties have indicated that they do not have any cross-examination for Sigfer witness Michael P. Gorman. And as such, Sigfer 2 and 3 would move that the commission excuse him from appearing at the hearing and that his direct testimony filed in docket number E-100 sub 179 on September 2nd, 2022, consisting of 31 pages of testimony, one appendix totaling 4 pages, and 2 exhibits titled Exhibit MPG-1 and MPG-2, totaling 27 pages, as well as his 3-page witness summary filed in docket number E-100 sub 179A on September 19th, 2022, be moved into evidence and entered into the record at the appropriate time.
Okay, hearing no objection to your motion, Ms. Kress, I will allow it. The witness's testimony will be copied into the record at the appropriate time, as will his testimony summary, and his exhibits will be accepted into evidence, and he may be excused from the hearing.
Thank you, Chair Mitchell.
All right, Mr. Rouse.
Yes, Chair Mitchell, the parties have indicated that they do not have any cross-examination for me, Brad Rouse, my witness. As such, I would move that the commission excuse me from appearing at the hearing for purposes of taking the witness stand, and that my direct testimony consisting of 57 pages filed in docket E-100 sub 179 on September 2nd, 2022, as well as my witness summary consisting of 3 pages filed in docket E-100 sub 179A on September 20th, be moved into evidence in the record and entered into the record at the appropriate time.
All right, hearing no objection to your motion, Mr. Rouse, it will be allowed. Your testimony will be copied into the record as if given orally from the stand. It will be copied into the record at the appropriate time, and your exhibits will be received into evidence, and you are excused from from participating as a witness in the hearing.
Madam Chair, on behalf of CCBA, we've obtained waiver from all parties who had stated that they had cross questions for Dr. Dinos Ganatas, CCBA witness. And all those parties, including Duke, have waived that cross. I understand that there are also no commissioner questions planned for Dr. Ganatas, so we therefore move and seek permission to excuse Dr. Ganatas from his appearance and to submit his revised testimony as filed on September 16th, 2022, and the accompanying 2 exhibits into evidence. His summary will also be submitted into evidence. That I expect to be able to file that along with Dr. DeFelice's this weekend, and that's to be admitted at the proper time.
All right, Mr. Burns, having heard no objection to your testimony, the witness's revised testimony filed on September 16th.
Yes, ma'am.
Will be copied into the record as if given orally from the stand at the appropriate time, as will his testimony summary and exhibits accepted into evidence, and he's excused from participating as a witness in the hearing.
Thank you very much.
Good morning, Chair Mitchell. It's Matthew Quinn with NC Warren and Charlotte Mecklenburg NAACP. We sponsored witness William E. Powers in this matter on September 2nd of this year. We filed and served the pre-filed direct testimony of Mr. Powers. In this docket, it consisted of 61 pages and 1 exhibit. There were no confidential information in either. All parties to this matter have waived cross-examination of Mr. Powers. Therefore, we would ask that Mr. Powers' in-person attendance of this proceeding be excused. We would ask that Mr. Powers' direct testimony be copied into the record at the appropriate place and time, as if he had read it from the stand. And finally, we would ask that Exhibit 1 to Mr. Powers' testimony be admitted into evidence. We've not prepared a summary. I see now that witnesses who are excused can offer summaries. We'd like the opportunity to do so, and I will, with the chair's permission, file such a summary.
All right, good morning, Mr. Quinn. Having heard no objection to your motion, I'll allow it. Witnesses' testimony will be copied into the record as if given orally from the stand, will be copied into the record at the appropriate time. as will the testimony summary to be filed. Exhibits to that testimony or exhibit to that testimony will be accepted into evidence, and your witness is excused from participating in this expert witness hearing.
Thank you, Chair Mitchell.
Good morning, Madam Chair. Nick Jimenez with the Southern Environmental Law Center. SACE et al. And NCSEA jointly sponsored witness Jay Kaspari. We have confirmed with all parties who had do not object to excusing Mr. Kaspari. We also conferred with Commission counsel and understand the Commission has no questions. So we would move to enter at the appropriate time Mr. Kaspari's pre-filed direct testimony consisting of 25 pages, as well as his report filed in E-100 sub 179 on July 15th, 2022, as Exhibit 2 to the joint comments of SACE et al. And NCSEA, as if given orally from the stand.
All right, having heard no objection to your motion, Mr. Jimenez, the witness's testimony will be copied into the record as if given orally from the stand at the appropriate time. The report that you identify, is that an exhibit to his testimony? Or are you moving that in independently of his
It's-
testimony?
It's independently of his testimony. It's an exhibit to our comments.
All right, we will, I'm going to hold on moving that into evidence as comments are already considered to be in evidence, so the document is in evidence.
Okay.
Did you all provide a summary of your witness's testimony?
We have not.
Okay, do you intend to?
We certainly will if the Commission thinks it would be helpful.
Okay. We would request that you do provide a summary of his testimony, and that summary will be copied into the record as if given orally from the stand at the appropriate time as well.
Okay. Thank
Any
you.
exhibits to Mr. Kaspari's testimony?
No.
Okay. All right. And Mr. Kaspari is excused from participating as a witness in this expert witness hearing.
Thank you.
Any other counsel for any other parties' motions at this time? All right. With that, any other preliminary matters before we turn back to public staff panel? Okay. All right, Mr. Shower, with you.
Thank you, Chair Mitchell. Good morning.
Morning.
Mr. Thomas, I'd like to start off on page 56 of your testimony.
Okay, I'm there.
So at the top on line 1, you testify that Duke's 4 portfolios selected 2 CCs to be built by the beginning of 2029. Is that correct?
Wait, did you say page 56?
46.
Oh,
I might have
sorry.
misspoken.
Okay, yes, I'm there.
Is that correct?
Can you restate the question?
The Duke's 4 portfolios select 2 CCs to be built by the beginning of 2029.
The original 4 portfolios, yes.
And the supplemental portfolio 5, which is endorsed by the public staff, selects 1 CC to be built by 2029 and 1 CC to be built by 2030. Is that correct?
That's correct. 1 CC was delayed.
Right. And for the supplemental portfolio 5, the modeling uses a no Appalachian fuel supply case. Is that correct?
That's correct.
Right. And I'd like to understand the assumptions of the no Appalachian fuel supply scenario that's used in supplemental portfolio 5. Do you have Duke's modeling panel direct testimony in front of you?
Yes, I do. I also have our detailed recommendations from our initial comments, if that's what you're looking for. I can go to the direct.
I think they say the same thing, but I'm going to talk about what I believe are 3 assumptions that are incorporated within the no Appalachian fuel supply.
Sure.
So
Can you
if
point me
could
to the
page 57 in the Snyder et al. Testimony summarizes the no Appalachian fuel supply case.
Yes, I'm there.
Right. And am I correct that the no Appalachian fuel supply case means three things. First, Duke's existing CC fleet would be fueled by Transco Zone 4. Is that
That's correct.
all right? And the second assumption is that there would be firm transportation of natural gas for 2 new CCs, correct?
That's correct.
Right. And the third assumption is that no CC would operate on ultra-low sulfur diesel backup, correct?
That's correct.
Right.
That last one is because in Duke's original portfolios in the no app gas fuel supply, they fueled combined cycles fully with ultra low sulfur diesel fuel in the month of January.
Do you recall that in the public staff's initial comments filed on July 15, the public staff expressed concerns regarding future natural gas supply and deliverability?
In general terms, yes, but I have those comments if you have a specific page.
Well, if you recall that in general terms,
Yes,
that's
in
fine,
general, yes.
Right. Does the public staff still have concerns regarding future gas supply and deliverability?
Yes, and Mr. Metz may elaborate, but yes, we do.
Sure. So I'd like to go back to the no Appalachian gas fuel supply assumptions. So the first assumption discusses Transco Zone 4. What is the basis for the public staff's assumption in supplemental portfolio 5 that Duke's existing CC fleet will be fueled by Transco Zone 4?
Let Mr. Metz elaborate.
Yeah.
So this is sort of the, probably heard the word balance too much, but this is a balance between modeling and operations. So in terms of modeling and the current Duke Energy fleet, Duke does secure Zone 4 gassing for its combined cycle fleet or for its natural gas use. Because there's an asset management agreement, more details probably than you want to probably hear right now. So we thought for purposes of modeling that since the existing natural gas fleet already can secure Zone 4 pricing, that it was appropriate to continue that current usage for modeling purposes looking to the future.
And my understanding is Zone 4 is Georgia and Alabama. Is that correct? Transco Zone 4?
Zone 4 comes a little bit into South Carolina, but
Okay.
yes.
And Duke's asset management agreement, does it currently provide supply for all of Duke's CC fleet?
My understanding of the asset management agreement that Duke Energy Progress and Duke Energy Carolina is essentially pool the amount of natural gas, period, regardless of which plant it goes to for its natural gas fleet.
And is there a firm pathway from Transco Zone 4 to all of Duke's existing CC fleet?
So as we're tying back to the asset management agreement, there is a composite of both firm and non-firm overall for deliverability.
So just to revisit that answer, does Duke have firm supply from Transco Zone 4 for all of its existing CC fleet?
I would have to go back and double check on all.
Okay. So the answer is you don't know.
I don't know.
Okay, thanks. Has the public staff or Duke provided detailed information in any of their filings on how Duke would secure natural gas from Transco Zone 4 to supply all of its existing CC fleet?
Can you please restate the question?
Has the public staff or Duke provided detailed information in any of their filings in this proceeding on how Duke would secure firm natural gas supply from Transco Zone 4 to supply its existing CC fleet?
In that detail, no.
Mr. Metz, I think the next line of questions with you as well. So the second component of the no Appalachian fuel supply assumption is that Duke would have firm transportation for its 2 new CCs, correct?
So the Duke's assumptions for the at gas scenarios for their combined cycles would have firm deliverability of natural nat gas. Yes, that was my understanding.
Oh, I'm sorry. I'm speaking of the no Appalachian fuel supply case that the public staff relied on in the supplemental portfolio. That assumption The public staff assumed that Duke would have firm fuel supply for the 2 new additional CCs that Duke intends to build in the near term, correct?
That is correct.
Mr.
And
Shower, you need to speak up or speak into the mic because I'm
Sorry.
having a hard time. I want to make sure I hear your questions.
Yes.
Okay.
Sorry, Chairman Mitchell.
And that is correct. And if you look at page 73 of our initial comments, we go into more detail of the reasoning behind the potential for firm transportation of new natural gas, non-nap gas.
And at page 73, do you discuss the Transco Southside project?
I would have to go back and double check if I called out that project by name, but they are the Williams Transco projects.
So even though you didn't call it out by name, your intention was to reference the Southside project?
There's 2 projects in questions, and I'm mixing up the names right now, so I can't remember the names right now.
Okay. But yesterday, I believe you testified that the public staff assumed that the Transco Southside project would provide natural gas to Duke's 2 new CCs, correct?
Correct.
Right. And you said you reviewed the Williams Transco website and found that the Southside project would provide 423,000 decatherms per day. Is that accurate?
I believe said subject to check on the actual decatherm usage.
Okay. But it was between 400,000 and 423,000, subject to check?
Subject to check.
Okay. And you said that the project would include upgrades to the Transco pipeline somewhere in Ardell County. Is that correct?
I believe they are starting at station 165, and I cannot recall right now how far south those upgrades went.
And you testified that if Duke could secure all 423 decatherms or all that was available because of the Southside project, that would be sufficient to fuel Duke's 2 new CCs in the near term?
Under the assumption that they are both, they move forward with the 1200 megawatt, approximately 1200 megawatt combined cycles. That's my understanding.
And what's the public staff's basis for assuming that Duke would be able to acquire all of the capacity from the new Southside project?
So this is, again, as I stated earlier, this is the balance of modeling that we are not approving or recommending approval of, nor has Duke asked for CPC in this particular docket. That, again, looking forward, say, is there a possibility that we can have natural gas to the combined cycles? And is that gas firm? Starting going all the way back to the P1 through P4 portfolios, Duke had modeled the alternate scenario in the case that there was not firm transportation. So that way they assume for the month of January, typically when the natural gas system constrained, it would run on ultra low sulfur diesel. I believe that that was a good stress to look at how the system can operate, what cost would it operate at, and what would the emissions be is an alternate or a sensitivity to say if that transportation did not come available at a later point in time.
Thank you, but I'm not sure you answered my specific question, so I just want to restate it. So what is the public staff's basis for assuming that Duke would be able to acquire all of the capacity from the Southside project?
From a modeling standpoint that we believed it was appropriate to include at this time, again, for modeling that the natural gas would be available. We're going to continue to monitor new natural gas pipeline or expansion of natural gas pipeline as we move forward.
Right. And I understand that you believe it was appropriate to include, but I'm trying to understand what's the basis for you determining that it was appropriate to include that as an assumption.
If Williams Transco says we're going to expand our natural gas pipeline, I think I made the assumption that it's reasonable to model that potential scenario as we look at all the different potential outcomes.
All right.
And I think if I could just add real
Please,
quick to
Mr.
this,
Thomas.
in terms of the modeling, I did just want to point out, well, actually, never mind, it's confidential and I don't want to get into that. So I just saw the note on the comments, so I'm sorry.
I'm not going to bring us into confidential session again. Why wasn't the Southside project mentioned in the public staff's initial comments or direct testimony?
One second, I'm looking back in the initial comments.
Okay. And please correct me if I missed it in either of those.
So looking at our initial comments at page 73, given the recent proposal for Williams Transco upgrade projects, however, the public staff supports the use of Henry Hub Zone 4 and Zone 5 gas pricing for modeling purposes and planning. So yes, so again, for context, given the recent proposals are found publicly on Williams Transco's webpage.
Okay, so it wasn't referenced by name, but that quote that you just gave me was the reference you intended to use to refer to the Southside project.
Again, I can't remember the exact names. There's two projects. There's one that goes through Virginia into North Carolina and almost horizontally. Then there's the main trunk upgrade. So
I also reviewed Appendix N of the carbon plan, in which Duke discussed fuel supply, and I noted that Duke makes no mention of the Southside project there, does it?
subject to check.
Right, and Duke also doesn't mention the Southside project in any of its direct testimonies or rebuttal testimonies. Is that correct?
I cannot recall.
Chair Mitchell, I do have an exhibit I'd like to introduce. With the chair's permission, I'd like to mark this as Tech Customers Public Staff Panel 1 Cross-Exam Exhibit 1.
Can someone help Mr. Shower so we could get this document marked?
Chair Mitchell, I believe everyone has copies.
Go ahead.
So the exhibit I just handed you, if I could orient you to it.
Mr. Shower, let's mark it first.
Oh, I'm sorry. Chair Mitchell, I'm moved to mark the exhibit as Tech Customers Public Staff Panel 1 Cross-Exam Exhibit 1.
All right, the document will be marked Tech Customers Public Staff Panel 1 Cross-Examination Exhibit 1.
Thank you. What I handed you was an exhibit I prepared. This shows a map from the Transco South Side project, which is from the Williams Transco website. Mr. Metz, when you reviewed the website, do you recall seeing this map on the website?
Yes.
Right. And on the bottom, I've included a map of Duke's existing generation assets, which is figure C2 from Appendix C of the carbon plan, just for reference. Mr. Metz, if you look closely, the Transco map says that the Iredell station, which is the bottom left little square, it's hard to read, I'm sorry for the size. The Iredell station will provide 264,000 decatherms. Do you see that, the 263.4 MDTH/D?
Correct.
All right. And then I'm looking to the right of the Transco map, and there's two more yellow dots, and those are in Northampton County and Hartford County, and they respectively will provide 120,000 decatherms and 40,000 decatherms. Do you see that?
Yes.
So based on this map, it appears that the additional 400,000 decatherms that are going to be provided because of the Southside project are going to appear both in Iredell County and then separately in the northeastern corner of the state in Northampton and Hartford. Am I understanding this map correctly?
So it was my understanding that when I was stating station 165 before, I was referencing station 166. It is my understanding that station 166, from my view, again, not a natural gas pipeline planner, that the modification at station 166 would alleviate the approximately 400,000 decatherms that was a referencing, then that could be directed down towards the bottom left and as well horizontally over to the right towards Hertford.
But based on this map, and I'm generally trying to understand this map, am I correct that it appears the alleviation caused by the upgrade at 166 will result in about 160,000 decatherms being available in the Northeast and about 260,000 being available in Iredell County?
It was my understanding it's up to 160 to the east through potential future expansion, but the modification at station 166 would allow the throughput down to that point.
So just so I understand your testimony, is it your understanding that the modification at 166 would allow all 400,000 decatherms to be available in Iredell County?
No, because the system, you're going to have system usage and system losses as you transition from Pennsylvania down to Iredell County. And again, we're not using location specifics for purposes of the modeling, so don't know for certainty if Duke will potentially locate in Rockingham or if they would locate south of the Iredell County.
But location specifics would impact whether or not Duke would be able to get firm supply of natural gas, correct?
Oh, absolutely.
Okay. So looking at both the Transco map at the top and figure C2 at the bottom, assuming Duke can secure all of the additional capacity from the Southside project, do you know how Duke is going to get 160,000 decatherms of gas from the northeastern part of North Carolina to whichever brownfield site it locates a new CC?
So if your question is asking of how they would build a pipeline out of predominantly, I mean, this Dominion Energy, North Carolina's territory, or Dominion's territory, down over into Duke Energy Progress, I don't think that would be a reasonable pipeline expansion project. However, the assumption is that they're going to predominantly branch off the main Williams Transco pipeline, the predominant trunk from Pennsylvania down to Iredell.
But am I correct in reading this map provided by Williams Transco that 160,000 decatherms would only be available from this branch that breaks off to the east, to the northeastern part of our state?
I would need to go back to review the detailed summary on the Williams Transco website for both of these projects.
Based on the public staff's initial comments, do you believe, and the testimony here today, do you believe that the public staff has provided detailed information on how Duke could secure firm transportation from the Southside projects to its new CCs?
What we looked at is pipeline projects that are, for pardon the pun, that are in the pipe that are potentially either underway or in review or has a potential for being possible to interconnect, understanding also evaluating projects that have been delayed, like the main MVP project. We thought it was reasonable for planning purposes within the model to allow that possibility of firm transportation.
Right, but you, I believe earlier said you don't know how Duke would be able to get gas from the northeastern corner of the state to a CC at a brown site. Don't you think that's an important detail?
Well, that's an important detail, but all the modeling assumptions for all the resources, I don't know how Duke's going to interconnect them. These are modeling scenarios, and we put cost inputs as proxies to evaluate a gambit of events. Mr. Thomas.
Yeah, I mean, I just kind of add to this. You know, there's a lot of uncertainty in the gas supply, right? So trying to understand, you know, not only what gases might be needed in North Carolina to kind of maintain system reliability is an important factor in this modeling, but you know, none of our comments and our testimony repeatedly, you know, emphasize that nothing in the near-term action plan is approving a natural gas plant, and I think, you know, the CPCM proceeding for such a plant would be the place where we would, you know, have some uncertainty resolved around the Transco Southside reliability project, other potential expansions, the MVP and MVP Southgate project. And obviously, the prudence of a gas plant at that time, I think, would be analyzed not only in the context of that specific gas plant, but the changing conditions entirely that may potentially render such a gas plant, not necessary. But I think we need to keep an eye on both the need for gas and the need for reliability. And that's why we felt it was reasonable in the capacity expansion model to allow for that incremental capacity for gas CCs.
So I understand that this is not a CPCN proceeding, but we are talking about the near-term portfolio that we need to move forward on the carbon plan.
Mhm.
And am I correct that the public staff supplemental portfolio 5 is affirming the need to build natural gas plants, but doesn't know where the gas for those plants will come from?
I think that, the witness and that's just testified that there's expansion projects in the works. Do we have a pipeline route to bring gas to whatever site that is eventually chosen for a CC? No, I don't have that CPCN application, that pipeline route in front of me. But I think that that's going to be part of future considerations. Those pipeline costs, are going to be an important determinant, and the route and the ability to actually construct it are going to be important in terms of deciding whether or not that is in the best interest of ratepayers. But I think we tried to make a reasonable assumption that the gas pipeline system needs expansion, and there are significant needs for natural gas, not only for electricity consumption, but for industrial customers. And so that gas has got to come from somewhere, and I think we thought it was reasonable to limit that gas to kind of acknowledge the existing projects in the pipeline, but to also acknowledge that there are limits to that, and there will be challenges associated with it.
And for further context, this has been an ongoing observation of ours since 2020 comments from the IRP. For purposes of the carbon plan, if those William Transco projects were not called out, we would have landed at a different scenario for SP5.
So Mr. Thomas, I was just thinking about your testimony yesterday regarding over procurement, where you said even though you're going to need 3 cars over your lifetime, you're not going to buy all 3 cars now. Let's say you need a car in the near term, and you don't know whether or not there's going to be gasoline in North Carolina. Would you buy a Ford F-150, or would it be more reliable to buy a Tesla?
If I didn't know there was going to be gasoline in North Carolina, and it's a good question. I think I'd have to have a better understanding of why there would be no gas in North Carolina. But I think when I'm sitting at my computer doing the spreadsheet calculations to figure out what would be the right car to buy, I think it'd be reasonable to try to entertain both options. But when I go to sign the paperwork, I think that's going to depend upon the knowledge I actually have at that time.
Right. And then if I had perfect foresight, then I absolutely know what decision I would make. But the challenge is here is that we don't have perfect foresight. There's a possibility with new developments, and we thought they were reasonable for planning.
Right, but there's also risks associated with those new developments not materializing.
That is correct.
Right. No further questions.
Thank you, Chair Mitchell. Good morning, gentlemen. Carrie Grunman on behalf of Walmart. I think I just have really just a couple of questions, and they are for Mr. Metz and Mr. Thomas. And I'm going to be asking both of you if you agree with portions of each other's testimony because they overlap. But can we start, Mr. Thomas, with your testimony at page 42?
Okay, I'm there.
Specifically looking at lines 4 to 6. You testified there that natural gas fuel consumption peaks apparently in both DEC and DEP in 2026. Is that correct?
Yes, and that's referencing figure 5, and that's both across DC and DEP. And I think I testified yesterday that, this, to me, the reason this is happening, because this is from the production cost models, which do not have a carbon limit because of the way Encompass functions. This is a reflection of the amount of renewable generation that's being added to the grid, and that is naturally displacing natural gas. And obviously, natural gas is often called a transition or a bridge fuel. And I think that this graph is really showing you that you need it for system reliability to serve load in the early stages of the transition, but by the time you reach 2050, you've really begun to phase out of that. But obviously, a lot of that depends on the prevalence of hydrogen. What's not shown in this graph is in P1 through P4, Duke made assumptions about hydrogen eventually completely supplanting natural gas, which would allow those plants to be more utilized. But there's a lot of uncertainty about the hydrogen economy, particularly in the face of recent events.
Mr. Thomas, thank you for that more fulsome explanation. I think my question just related to when it relates to the company's near-term action plans with respect to new natural gas, you would agree with me that none of those proposed plants come online before 2026.
Yes. That's
Okay.
right.
And so by the time these plants come online under the company's proposal, would you agree with me, and I think part of your answer suggested this, that the plants that the company's proposed to build under the near-term action plan are more useful for reliability purposes and bridge purposes, as you indicated?
If I could restate your question, you're saying that the existing plants are more utilized or the new plants?
I'm focusing on the proposed plants that the companies want to build or have selected as part of its near-term action plan. When those plants are built and presumptively in service in late 2029, 2030, because you here indicate that natural gas consumption reaches its peak in 2026, when these new plants go online, are they predominantly to serve a reliability need?
I think it depends on the plant. I think CTs, absolutely. And I discussed that later in my testimony. The CT capacity factors, at least in the model, are very low. The CCs continue to serve, both capacity and energy. And I'd note that, what I didn't really discuss much in my testimony, but these plants are also providing ancillary services, operating reserves that allow for not just to enable us to have sufficient capacity to meet demand, but also to be able to respond quickly and to provide the spinning reserve, the black starts, all those ancillary services that are required to maintain system reliability, such as power quality and voltage support that are not necessarily reflected in the Encompass model outputs.
And so then I'd like to turn to Mr. Metz's testimony on page 56, looking at the graphs that are shown there. And yesterday, I believe there were some questions to you, Mr. Thomas, about the servo model and the LOLE. I think it was, I just want to summarize your testimony. Let me know if I've misstated it. But yesterday, I think you indicated and confirmed that staff didn't actually have the ability to go in and run Servum, but you're generally familiar with the program and you didn't really have any reason to question the results. And I think those results, though, are set forth in Mr. Metz's testimony. Is that fair?
Yeah, that's correct.
Okay. And then can I ask you both to turn to Mr. Snyder with the modeling panel's direct testimony, specifically looking at page 202. And maybe keep your finger on Mr. Metz's testimony while we sort of toggle back and forth between Mr. Metz's testimony and page 202 of the modeling panel's testimony.
Yep, I'm there.
Would you agree with me that if we are looking at the graphs that are on Mr. Metz's testimony and the graphs that are in the modeling panel's testimony on page 202, that they are identical, except that the modeling panel's testimony also includes the results under Servum for the Synapse optimized and the Gable Stratagem preferred portfolios?
Yes, they're the same graphs, but we had only been really focusing and talking about the reliability of our SP5, and so we had simply removed the extraneous, the other model results.
Okay, and so when it comes to your prior testimony about not having any real concerns about the reliability or validity of the Servum model's results, is that also true with what we see on page 202 of Mr. Snyder's testimony?
You're asking me if I have any reason to doubt the analysis of the alternative modeling portfolios in the Servum model?
Correct.
No, I do not.
Okay. And so then would you also agree with me if we just take a look at what's identified as the Synapse optimized portfolio on page 202? Do you see that in the 2030 timeframe, it is almost It is below the 0.253 LOLE threshold,
Yes, and it's above that threshold in 2035.
but just focusing on 2030 for the time being, you agree with me that it's below it, and that reflects that portfolio as of 2030 is reliable based on the analysis of thousands of different model runs, correct?
Yes,
Okay. And then you agree with me that when we look at 2035, that portfolio does, under the company's LOLE analysis, appear to exceed that LOLE threshold.
yes, that's what the graph shows.
And would you agree with me, and it's okay if it's subject to check, that the company's threshold for the Synapse Optimize, that although well, let me try to explain it again. The graph goes from 2030 to 2035. Would you agree with me that subject to check, that for purposes of the Synapse Optimize, that it actually doesn't exceed until 2035 as opposed to any prior year between 2030 and 2035?
I think that's difficult to know because I believe Duke that only runs certain years. They don't run this, for the whole planning horizon. They select certain years to run. So I couldn't know when it actually broached that limit.
If I'm correct, let's assume for purposes of my question that the reliability issues using the company's Servum results aren't triggered until 2035. Can you agree with me? You understand the basis for my hypothetical?
Yes, I do.
Okay. And are you aware as to whether the Synapse Optimized portfolio includes any new natural gas?
I do not. Subject to check. I do not believe the optimized does.
Okay. And so again, back to my hypothetical that the trigger for the reliability isn't until 2035. Would the company have sufficient time to build natural gas plants for a reliability purpose if it waited until the 2024 carbon plan and potentially later to put those issues back before the commission if the reliability issues aren't triggered until 2035?
So if I understand you correctly, you're asking me if your hypothetical is true and the Synapse Optimized portfolio is reliable until December 31st, 2034, and then suddenly in that 2035 it is not reliable, you're asking if the commission would have time to make adjustments prior to that veering into unreliability?
I think that's correct. If the commission could wait for purposes of this proceeding to make a decision on natural gas and defer that to a future carbon plan proceeding.
I think based upon this sole analysis here with the LOLE results, you could come away with that conclusion. But I'd also point out that I think that the Synapse model, while they did use Encompass, they did change some of the commitment settings in terms of some of their production cost models, and I've played around with that a little bit, and that does have an impact. But I think there could be time to adjust. It really depends on what kind of adjustment is necessary and what type of capacity needs to be installed. But I'd have to review again the additions in the Synapse Optimized to see what kind of capacity it was calling for in that 2030 to 2035 timeframe.
But we'd also have to look at what resources were selected, because again, looking at the model as it was projecting out to 2035, we may have, for lack of a better word, overbuilt in these early years and created a problem and just had to essentially place more costs and more risk to fix the problem.
But you would agree with me that under the sort of prevailing phraseology that we may have heard more than a dozen times, under the carbon plan, we can check and adjust, and that would include checking and adjusting in 24 months in 2024, correct?
That's correct. But I would be cautious if we're going to be overly procuring and just creating a further challenge for us down the road. Or Mr. Thomas.
Yeah, and I think what one thing I'd kind of point out here is the Synapse model, assumed different capital costs and then also used different commitment models for arriving at its preferred portfolio, which did not add gas by 2030. But I think we need to recognize that there's fundamental differences between how Duke ran the model, how we ran some of our Compass models, and how Synapse did that might, that these under this hypothetical that the reliability issues only emerge in 2035. I think that's a risky hypothetical to make. They could just as easily appear in 2031. I think it depends a lot upon the coal retirements and the firm capacity that can be obtained from some of Synapse's more aggressive battery storage additions. So I think we need to weigh holistically the risk, and it's maybe risky to go down. I truly believe in the check and adjust strategy here, and I think that we need to look at that not only in the updates and the carbon plan proceedings, but also in future CPCN proceedings. But yes, I think we need to maintain reliability, and we can't wait too long to discover that our system is not sufficiently reliable.
But wouldn't you agree with me that a fundamental principle to a natural gas plant providing a reliability function is to have a fuel source to be able to power it?
Yes.
Okay. And do you happen to know the original expected date that the MVP project was supposed to be completed when it was originally proposed?
Subject to check, but I think it was like 2020.
Okay, so we're 2 years behind that. And would you
Yeah.
agree with me that if we waited a few more years, well, let me back up. Do you understand that FERC has recently extended the construction permit for MVP by 4 years?
I believe so. I think it currently has an in-service date of summer 2023.
And so if we were to wait until presumptively the 2024 carbon plan, if MVP is successful in coming online in 2023, would you agree with me that we would know a couple of things? That it's actually built. Do you agree with that?
Yes, we would know the status of that.
We would potentially know whether the company had in fact been successful in securing firm supply.
We could. I don't know the status of those negotiations, but that could be a one source of uncertainty that would be resolved.
And would you also agree with me that regardless of the commission's decision in this carbon plan, if the company truly believed that it needed new natural gas, that nothing would prohibit it from proceeding to file a CPCN prior to the 2024 carbon plan?
Yes, that's my understanding, that nothing would prohibit the company from making such a filing, but we would review that, vigorously as any CPCN application.
Real briefly, and I apologize, I don't know, Mr. Thomas, I believe you had some testimony in your direct testimony as it relates to offshore wind. And give me a second, I'll try to find it. Oh, it's page 34.
Sure, and I just wanted to emphasize that I focus more on the modeling aspect and Mr. Metz on the near-term development, but go ahead.
Well, to the extent that I've asked the wrong person,
Sure.
Please let me know. But Mr. Thomas, what caught my eye was your testimony on page 34 about there being no guarantee that the more advanced Kitty Hawk offshore wind resource can be secured by Duke, as electric public utilities in Virginia also have stringent carbon reduction goals under the Virginia Clean Economy Act.
Yes, and I believe Avangrid's testified that they would be open to negotiating with Duke, but I'm certain that there are those goals in Virginia as well.
But do you, just curiosity, I believe that I'm not going to reuse it, but I believe a copy of the Virginia Clean Economy Act was previously marked as an exhibit. But have you had any occasion to review that legislation?
I'm generally familiar with the scope and some mandated resources and a renewable portfolio standard as well, but I don't know the exact quantities.
And so you're familiar then under the Virginia Clean Economy Act that Dominion, Virginia was statutorily authorized to choose to construct that project and does not have any statutory obligation to use a third party to develop offshore wind?
If I recall correct, the VCA mandated that Dominion move forward with the CVOW project. But my understanding was there was additional incremental offshore wind or renewable resource requirements beyond simply the one project that Dominion is building currently.
Well, we can obviously refer to the statute to consider that, correct? But you are familiar that Dominion Energy Virginia did opt to move forward with the Coastal Virginia offshore wind project as the owner, operator, and developer of that project, correct?
My understanding is that they are currently, but there's some, I believe they recently entertained the idea of withdrawing the project due to some performance guarantees imposed by the commission up in Virginia. But yes, I know that they're moving forward with that.
And that I believe the project cost for that, I think it was approximately $9.6 billion.
Subject to check, I believe so.
I believe the most recent estimate is 9.8 billion.
Thank you. Those are all the questions that I have.
You're up, Duke.
Chair Mitchell. Gentlemen, how are you? Before I get started, I've got a few documents that I'd like to pass out. These are in the record of the proceedings, so I'm not going to mark them as exhibits. I think you'll be familiar with them, but I think passing them out will help expedite the process. Thanks.
So all of them we can pass behind us.
All right. So gentlemen, my questions, or at least the first line of questions, is going to be predominantly for Mr. Thomas. Mr. Metz, if you have input, certainly welcome that. Mr. Williamson, probably coffee time of the day versus Coke time of the day, but don't have a lot of questions for you. And then Ms. Link will have some questions for Mr. Metz towards the end. So would like to start by focusing on near-term actions. And Mr. Thomas, I think your testimony and some of your testimony yesterday found that the company's general approach to presenting multiple portfolios and then presenting a discrete near-term action plan was a reasonable approach for this initial carbon plan. Is that right?
Yes.
And you also, or would you agree with me that it was reasonable for the companies in presenting the carbon plan to ask the commission to select a certain discrete volume of resources, supply side resources, for execution between now and the next carbon plan update 2024?
Yes, I think that we may have different approaches on how we calculate that number, but yes.
Okay. And the first page in the materials that I handed out to you is something that I think you'll be familiar with, but this is page 20 of the public staff's comments that were filed on July 15th.
Yes.
Familiar with that? And just to set the stage, so to speak, this is preceding the public staff's more detailed recommendations in your comments where you requested / recommended the companies undertake supplemental modeling. You recall that?
Yes.
Okay. And the second sentence, and I'll just read it briefly. Public staff requests that Duke complete P5 model run and determine if the short-term execution plan detailed in this petition, particularly item 3A, still aligns with the results from P5. Duke should provide the model results supplemental filing no later than August 19th, 2022. To the extent that actions identified in the short-term execution plan are validated by the P5 model run, the public staff recommends approval of those actions within the near-term execution plan. Is that your comments?
Yes.
And item 3A, that's item 3A from the company's petition, which laid out supply side resources, solar plus storage, wind, and gas, correct?
Yes.
All right. And partly I wanted to come back to your comments just to reflect that this was July 15th, so approximately 60 days ago.
Yes, I believe that's when we filed it. Yes.
Right. And just a significant amount has happened since then. The companies very rapidly undertook this analysis, correct?
Yes. Yes.
Filed it on August 19th, and then your testimony filed September 2nd, and we're moving very rapidly to this hearing where we are today.
I think we've all been under compressed timelines here.
It's been a compressed timeline. So turning to page 6 of your testimony, where you're summarizing your testimony in the case, and I think you touched on this briefly yesterday, at lines 12, starting at line 11, actually. It's finally, I discuss Duke's near-term procurement activities associated with an interim compliance date of 2032, and find them generally reasonable and recommend the commission approve or revise 2022 solar procurement of 1,200 megawatts. Did I read that correctly?
You did, although I would note generally reasonable doesn't mean we completely agree on the quantities, and I discussed some differences later in my testimony.
Okay, good. Well, that's
It's directionally accurate, I guess, maybe would have been.
well,
more
that's what I want to talk about and explore, because at the end of the day, the commission is tasked with developing a carbon plan and has to select a discrete amount of resources to be executed or developed, procured between now and 2024. Agree with
Yes,
that?
yes.
All right. So the second document, which I expect you'll be familiar with, is this is rebuttal exhibit 1 from the modeling panel's rebuttal testimony, but it's also table 1. Are you familiar with this?
I am, yes.
Okay. And if have you had a chance to fully review the modeling panel's rebuttal testimony?
Generally, yes, but if you'd like me to reference a particular page.
Sure. Around pages 21 to 24, and you don't have to go there if you're welcome to, but they spend about 3 or 4 pages dissecting your page 63 table and then how that related, contrasted to the near-term actions that the companies presented in the carbon plan. Is that your recollection?
Yes, yeah, they talk about the different years and the solar and storage resource selections specifically.
Okay. And so that was summarized generally in this rebuttal table 1, which identifies the years supporting deployment, and then Duke's proposal, public staff proposal, and also provides details on intervenor alternative modeling proposals. Is that accurate?
That's what the table shows, yes.
Okay. And can you, well, maybe let's ask it this way. So would you agree with me that your table 63 assumed both incremental solar and storage to be placed in service in year 2029, as well as some what Duke called, I guess there were earlier resources in 23 to 25 on the solar side, and then some resources that were predetermined GSA, they were forced into the model.
Yeah, I mean, and that would include the 441 megawatts of CPRE solar and the approximately between 75 and 150 megawatts that might drop out of tranche 2 as well.
Right. And so the third page, which we can spend time on if it's helpful, but this was from rebuttal table 2 on page 23 and walks through what the company's near-term actions included versus did not include versus what the public staff did.
Yes.
Okay. And so at the end of the day, do you agree with the representations in rebuttal table 1 of the volumes of solar, storage, standalone, onshore wind, CTs and CCs represented here as the public staff's proposal?
So I think that generally, if we're talking about an apples to apples comparison, I think that these are approximately fair comparisons. But I think I just want to note that, when I prepared my table 3 in the testimony, I think I was looking at, first of all, I think that the 2024 carbon plan will obviously be an opportunity to revisit this. There is no guarantee that a final order in that proceeding will be available in time to implement the 2025 procurement of solar and solar plus storage. So I think what I had attempted to do, and maybe perhaps I should have elaborated on this more in my testimony, was to show the commission, this is what is being procured prior to 2030. This total quantity that I presented, which was more than what Duke had in their table, and then they removed that in service by the end of 2029. I think those resources are important for the commission to see and to understand, and it also shapes not only the near-term plan, but also where that rubber hits the road and the volumes that we're procuring in the 2022 solar procurement. I think Duke stuck with their recommendation of the model picked 750 megawatts in 2026, and so the 2022 procurement should be that 750 megawatts. And I tried to take a more holistic view and say, this is what we need over the next 4 years. Let's try to average that out with recognizing certain constraining factors like locations in locating some solar in DC and recognizing the red zone upgrades aren't included, but trying to somewhat front load to not only stress the interconnection process to see what we can really achieve, but to also set us up for potentially exceeding those targets and being able to reach compliance earlier than 2032, which kind of complies with our looking at the importance of the 2030 deadline, but also recognizing the trade-offs between cost and reliability and executability with CO2 reductions.
Thank you for that. And just one clarifying point. You mentioned your proposal of 1,200 megawatts for 2022 solar procurement. Would you agree with me that Duke's proposal effectively gets to the same place because they had assumed the 441 megawatts of CPRE would be in the baseline? So now Duke is also proposing 1,200 megawatts for a 2022 procurement.
Yes, I think if when I originally did the calculations of my testimony, I believe I had arrived at approximately, if you were evenly to spread out this 4-year procurement target over 4 years, I believe it was something around 1,440 megawatts. But we recognize there's challenges associated, particularly in the near term, and so we tried to adjust that slightly to still front load and attempt to achieve a little bit earlier, but also to recognize those system constraints. So I think we were trying to find a balance, and I don't. One thing I want to emphasize is the 750 megawatts chosen in 2026 is, a subject of that interconnection limit, and the only way we'll know if we can exceed that is if we attempt to interconnect more than that. And I think the 1,200 megawatts proposed both by Duke and by the public staff in their 2022 procurement volume, would attempt to reach that balance and potentially, hopefully, achieve compliance earlier than 2032.
Thank you. And so we're aligned on the 2022 solar procurement volumes. And so we've got Duke's proposal of near-term actions, and then we've got the public staff's proposals, which have slightly lower or somewhat lower levels of standalone solar, and then somewhat higher levels of paired storage, and then standalone storage. And just referring back to your testimony on page 6, and I think you said it was directionally consistent. I think where does the public staff agree with Duke's proposed near-term action plan as reasonable for execution and selection by the commission between now and 2024?
Well, I think the issues with, the near-term action plan proposed by Duke are, we want to make sure that we're appropriately getting the right resources. And I think that, the near-term action plan did not recognize, in my opinion, the near-term action plan proposed by Duke did not recognize the additional benefits provided by solar paired with storage that were revealed in SP5. So I think that that's an important distinction to make. And certainly when you're talking about thousands of megawatts, a difference of a few hundred here and there may not seem a lot, but 220 megawatts of additional solar plus storage, and 130 megawatts of standalone storage, potentially being able to displace a certain amount of standalone solar. I mean, I think that would be in the interest of ratepayers, not only in the near term, but also as these resources are put into place and as they begin service. So I think there's nuance there, and maybe they might appear slight, but I think these are still a lot of facilities, still a lot of megawatts, and still a lot of some difference there that I think we need to acknowledge, because SP5 did allow that solar plus storage to provide more value in a more accurate representation, I believe, of how the system would actually be operated, and those differences I think need to be acknowledged.
Thank you for that, Mr. Thomas. I want to turn now to what's represented as the alternative proposals by the tech customers, AGO, CPSA, and NCSEA et al. Have you had a chance to review the table specifically as it pertains to those alternative recommendations?
Generally, you're talking about rebuttal table 1?
That's correct.
Yeah, I've reviewed the table. I understand that some of these were pulled directly from model results or test or comments, but yes.
That's correct. And to the best of your knowledge, has Duke accurately presented the near-term actions of the other parties' alternative modeling?
I believe so, yes.
Okay. And just for contrast, I think, slight differences, or however you characterized it, between Duke's proposal and the public staff's proposal, would you agree with me that there are material differences between those two proposals for near-term actions to be selected by the commission and the alternative plans presented by other parties?
Yeah, I mean, looking at the table, I think, the AGO is clearly the most aligned. The Attorney General's office is most clearly aligned with the exception of gas, but the other portfolios do call for what I would call significant differences, 1 to 2 gigawatts. So yes.
Yeah, and let's just to drill down a little bit on that. So the bottom half of the table under the differences columns reflect obviously differences from the Duke proposal. For tech customers, they add 350 megawatts of solar, but then they add additional 2,900 megawatts of batteries, which is a significant deviation in the near term from the Duke selectable resources. Correct?
Yeah, I would refer to that as significant, yes.
And then interesting, CPSA had 1,700 megawatts of solar and 1,050 plus megawatts of paired with solar storage, but eliminates standalone storage completely from their proposed portfolio.
Yes, I believe that from this table, I'd have to look back at their actual results to verify, but from this table, yes, they shift almost entirely to solar and solar plus storage.
Right. And in contrast to that, NCSEA, the Synapse optimized portfolio adds or takes away any paired storage and adds 3,000 megawatts of standalone.
Yes, that is correct, yes.
You may recall this at 4,000 megawatts of solar standalone and 4,000 megawatts of storage standalone as their near-term actions.
Yes, and I think that's, I think we can discuss it. We don't need to get into it, but that, obviously may reflect how the solar and storage is modeled, right? The fact that the standalone can charge from the grid versus the solar coupled cannot. I mean, that may play into those exact numbers, but yes, I'd agree the table is showing this.
Yep. And just to follow up on some questions counsel for Walmart asked you a few minutes ago, you recall that she asked a hypothetical about the LOLE validation step the companies undertook.
Yes.
And specifically whether the Synapse optimized portfolio was unreliable in December 31st of 2034 or 2031 based on the survey analysis companies undertook.
Yes, it's difficult to know when it became unreliable, but somewhere in that time frame it would happen.
And would you agree with me the more fundamental question, considering that Synapse optimized portfolio is recommending 4,000 megawatts of solar and 4,000 megawatts of storage to be interconnected in the near term by the end of 2028, that's not executable?
I wouldn't say it's not executable. I think it presents additional risks and challenges, but I don't know that I would say it's not executable. I also think that, particularly with regards to the storage, right, we haven't seen a lot of interconnection of storage. Much of this would presumably be utility owned and hopefully competitively procured. But we don't really know how that will be interconnected, where it will be interconnected, whether it'll be able to take advantage of surplus interconnection requests or replacement generator interconnection requests. So certainly those higher numbers present a challenge, but I wouldn't call them impossible necessarily over the next 4 years.
But you would agree with me that based on the public staff's recommendation and recognition that the solar interconnection constraints the company used in portfolios 2, 3, and 4, that those volumes significantly exceed what the public staff determined was reasonable for planning purposes?
Yes, they did exceed what we found to be reasonable. Yes.
Thank you. Could you turn to page 53 of your testimony, please?
$53, I'm there.
Okay. And on line 8, and you discussed this testimony some yesterday with Counsel for Tech Customers, but this goes to the reasonableness of the company's resource cost and technological characteristics assumptions using the carbon plan. You recall that?
Yes.
And based on your detailed review of the carbon plan inputs and assumptions, you found those resource costs and technological characteristics to be reasonable. Is that accurate?
Generally, yes. I think we stressed a few of the models with changing some costs to kind of understand what the implication would be there in our investigation. But yes, we did not find them to be unreasonable.
Right. I want to specifically focus on the assumed costs for combined cycles and combustion turbines that you spoke about with Counsel for Tech Customers yesterday. You recall that?
Yes.
Okay. And both yourself and Mr. Metz explained over a series of questions that Duke's approach to calculating economies of scale adjustments and assuming that a new combined cycle or combustion turbine would be constructed at an existing site are reasonable assumptions. Agree with that?
Yes, I believe that's what we testified to. Yeah. And Noting that we review those CT costs pretty extensively as well in the avoided cost dockets.
Right. And would you agree with me that there's nothing in the carbon plan that suggests Duke is planning to construct a new single unit combustion turbine at a greenfield site?
No, the carbon plan is not site specific, and no, I would expect that you could make every effort to locate at a brownfield site.
Okay. And do you have Appendix D to the carbon plan with you by chance?
I don't have a.
That's all right.
I think Dustin
I can.
does.
Yeah, actually, Mr. Story.
We got it.
Yep. Chair Mitchell, I'd like to introduce the cross exhibit if I could, please. I think this will. Great. That goes to commissioners. Thank you. Just give it so much. And Chair Mitchell, whenever you're ready, I can mark this as Duke Energy Public Staff Panel 1 cross-examination exhibit. So thank you. Mr. Thomas, have you had an opportunity to review the document?
Yes.
And on the bottom half of the page, I'll represent that this is table D2 from Carbon Plan Appendix D. See that?
Yes.
And that appendix and table summarizes the number of CTs the company has, the various generating sites operated by DEC and DEP. You familiar with that generally?
Yes.
And I'll represent to you that the top half of the exhibit is a summation of the data at the bottom half and identifies each of the sites the company owns and operates and the number of units that are CT units that are operating there.
Yes, this appears to be accurate.
Okay.
I'd have to check, but it looks accurate.
All right. And would you agree, based on your knowledge and experience and what's represented here, that for every company-owned site that there are at least 4 CT units or there's other generation co-located at the site?
Yeah, if I could, just to the establishment of the facts in the notes section at the top. Those facts have been established. And introduced.
I'd be glad to spend some more time on that, more based on his knowledge and experience. If he can represent that he's familiar with these sites and the notes look accurate, then we can move this along.
All right, I'll sustain the objection taken through the background.
All right. So, Mr. Thomas, do you see the notes column on the right side of the upper chart?
Yes.
And for the sites that are identified, would you agree with me that the Richmond Smith facility, there's, to the extent that you know, 5 combustion turbine units, as well as that there's a combined cycle unit that's located at that site?
Yes, I would agree.
Okay, thank you, Mr. Metz. And similarly for Wayne, there's both 5 CTs there, as well as the HF Lee combined cycle facility.
That is my understanding, yes.
Okay. And could you look down the remainder of the notes and would you, based on your knowledge and experience with the company's generating fleet, identify any facilities where the notes don't seem to be accurate in terms of co-located combined cycles or multi-unit sites?
The notes probably reflect what they're stating.
Okay. So based on your understanding, the company's got this right and they know the number of combined cycles and CTs at their various generating sites?
Yes.
Okay, thank you. So Based on this, would you agree with me that it's reasonably likely that the company plans to construct a new combustion turbine at a site where there are existing CTs operating today, and so they would not be a brownfield site? Would you agree with that?
They would be a brownfield site?
They would be constructing in a brownfield site.
Yeah, I think that's a reasonable assumption, yes.
Okay, thank you.
Expectation, perhaps.
Thank you. All right, could you turn to page 46 of your testimony, please? All right.
I'm there.
All right. On line 13, you state that the public staff also finds Duke's natural gas combined cycle configurations and operable life assumptions to be reasonable. Do you see that?
Yes.
And is it accurate in your understanding that Duke allowed the model to select between F-class and J-class units in the supplemental modeling?
Yes, both were permitted in the supplemental modeling.
And which unit was selected in the SB5 that the public staff found
For,
to be reasonable for planning purposes?
for CCs, the J class was selected.
And that's a 1200 megawatt unit.
Yes.
And in all portfolios, is it accurate that both the four P1 through P4 portfolios presented by the companies in the initial carbon plan, as well as in the supplemental modeling, that the modeling selected J-class units?
I think the conclusion about that, the selection between the two can really only be drawn from SP 5 and 6, because in P1 through P4, the F class was not an option to be selected, so it didn't have a choice. But in SP 5 and SP 6, it had a choice, and it still selected the 1200 megawatt unit.
That's good point. Thank you. Turning to your statement about operable life assumptions, you see that?
Yeah.
In the question, you speak to the reasonableness of the company's operable life assumptions,
Yes.
and you said you found those to be reasonable. Just remind the commission briefly, when you say operable life, what do you mean by that?
So there's two ways that the life of the unit is kind of used in the modeling. The first is the operable life in Compass. So that's the lifetime that's the unit is online. And I think in that case, it's essentially beyond the end of the horizon period in any case. And then it's used again in the calculation of the conversion of a capital cost in dollars per kW into the real levelized fixed charge rate that's used actually in Encompass. And I believe in that case, subject to check, I believe it was 35 years, I believe. I'd have to double check, but it appeared reasonable for what we would expect such a unit to operate for.
It's 30 or 35. I can't recall the exact number.
So subject to check 35, and if we looked at chapter 2, it would say it was 35 years subject to check.
Yes.
Subject check.
All right, thank you. And subject to check, do you recall that certain other interveners, Synapse and Attorney General's office experts, use significantly shorter operable life of 20 years? Do you recall that?
I do, and you know, I wouldn't necessarily call those assumptions unreasonable. I do think that those interveners are attempting to address the risk of stranded assets, of these assets becoming stranded and retired early, much like some coal units have all over the country. So I think it's reasonable modeling assumptions. Differences can be made, and I do think that that's a reasonable effort to attempt to identify that risk. So,
all right. Did you hear Mr. Snyder's testimony sometime last week?
I was here for it.
Okay. Do you recall Mr. Snyder responding to the concerns about stranded asset risk by suggesting that one of three things will come into existence, or are likely to come into existence, by the late 2040s? Either one, the hydrogen economy will become viable. Two, there will be an offset market that comes into an existence, which is authorized by HB 951 to enable the amount of combined cycle generation the companies would have online. Or three, there's flexibility in the legislation to enable the companies, for reliability reasons, to continue to operate past 2050 with some limited carbon emissions. Do you recall that testimony?
Yes, I do recall. Although I note the legislation limits those offsets to only, I think, 5%.
That's right. And he had a number of how many gigawatt hours a year. That was
Yes, and that
pretty
was,
significant.
yeah.
Okay, thank you. All right.
I would just say pretty significant subjective. I think it was about 8,000 gigawatt hours, and something to check. I think that's less than 10% or so of system demand. So it's something, but yeah, it's not like
It's
extensive.
5%.
Yeah.
All right. Do you recall that the tech customers in their alternative resource plan by Gable and Stratogen completely excluded combined cycles as a selectable resource?
Subject to check. Subject to check.
Okay. And would you agree with me that that's not a reasonable planning assumption to completely eliminate combined cycles as a selectable resource in the carbon plan?
I think from my perspective, there can be disagreements on modeling assumptions. If in that report, if those resources are excluded, much like in Duke's alternative gas portfolios that they submitted with the original carbon plan, they prohibited the selection of the larger J-class CCs based upon fuel supply assumptions. The assumptions made about the lack of natural gas supply could have caused them to eliminate the selection of CCs from their modeling. I think that those, we've talked a lot about the risk of natural gas supply not being here and the CCs not being able to be supplied. And if someone made that conclusion, which I would not say that conclusion is unreasonable, they would necessarily want to eliminate CCs from being selected by the model. However, I think that a more appropriate method might be to still allow the model to select the resource, but simply to limit the amount of gas that's available to the system. They would essentially accomplish the same thing, but one is a more physical constraint versus one is a more artificial constraint. So I think that the discussion about gas supply is very reasonable to have different opinions on whether we will get gas in the future. I don't know, and I don't think anyone in this room knows for certain what we will have in the next 6 to 10 years.
Thank you, Mr. Thomas. And just to be clear, the public staff's SP5 and the assumptions that you found to be most reasonable for planning purposes assumed a 35-year operable life and assumed that a combined cycle combustion turbine was a appropriate selectable resource in developing a least cost plan for North Carolina.
Yes, like I said, I find that the assumptions Duke used in terms of that supply and in our SP5 were reasonable, but I just was responding to your question if you thought it was unreasonable to prohibit a CC, and I would not agree necessarily that that's an unreasonable choice.
Thank you. Could you turn to page 51 of your testimony, please? So yesterday you received some questions from both Council for Avangrid as well as Council for Tech customers regarding Duke's approach to modeling onshore wind resources delivered into DEC. You recall that?
Yes.
And counsel for those parties seem to be suggesting that based on their understanding of Duke's modeling approach and your testimony that Duke may be conceding that if off-system resources are selected as part of the carbon plan, then there would be some flexibility in the ownership requirements under House Bill 951. You recall that?
I recall that line of questioning, yes.
Okay. And you addressed this issue and your understanding of the company's modeling at page 51, lines 4 and 5 of your testimony.
Yes.
Okay. Got one additional exhibit I'd like to pass out, please. Commission. Thank you.
Thank you.
Chair Mitchell, I'd like to mark this as Duke Energy Public Staff Panel 1 Cross-Examination Exhibit 2, please.
All right, document will be marked as Duke Energy Public Staff, Panel 1, Cross-Examination Exhibit 2.
All right. Mr. Thomas, I'll represent to you that this is a data request from the public staff to Duke Energy, data request number 13-5. Look
Yes.
accurate, and are you familiar
Yes,
with
it
this
does.
document?
I know that this was a data request sent quite a few, yes.
Yes, you did. So the question that you asked was, do the companies assume any onshore, offshore wind that's selecting the carbon plan must be utility owned, or are they assuming that a PPA from a merchant generator would suffice? You see that?
I do.
And the companies explain that their modeling assumptions are that any onshore or offshore wind shall be utility owned in accordance with House Bill 951. And this, if you go on to the second paragraph, specifically explains that for DEC, they were assuming that there were wheeling costs for imported wind into DEC. You see that?
I do.
And while the data response doesn't get into the details of how the costs were calculated in the model, are you familiar with, or would you accept subject to check that the companies assume that the unit that they were inputting into the model was a utility-owned asset versus a PPA?
Yes, and I did actually, after this conversation yesterday, I did go back into the Encompass model just to double check. And it does appear that this particular portion where I said Duke made the decision to model these resources as a PPA was incorrect. They did model these as utility-owned resources with similar to those in DEP with a wheeling charge. I would, I think the public staff in general, and I think the commission should be cautious of, Duke acquiring off-system resources and to ensure that those are properly acquired. I don't think it's necessarily. I worry about Duke going and simply building, onshore wind facilities in MISO or PJM and then securing a path and the transmission costs there. But I will acknowledge that this testimony here is incorrect in terms of how it was modeled.
Thank you, Mr. Thomas. Those are all the questions I have for you. Ms. Link has some questions for Mr. Metz.
All right, before we begin, Ms. Link, let's take our morning break. We'll be off the record now. We'll go back on at 11:15.
My name is Vishal Link on behalf of the companies. Mr. Thomas, I'd like to start with you. I've got two areas. One area is about new nuclear. The other area is about offshore wind.
Sure.
So starting with new nuclear. I understood from your testimony yesterday that you agreed it was reasonable to include SMRs in the modeling, correct?
Yes.
And you agreed that the companies made reasonable assumptions on commercial availability of SMRs, correct?
Based on what we know today, I think they were reasonable, yes.
And you agreed that 2032 was a reasonable date for SMRs.
I think it's
Correct.
aggressive, but reasonable, yes.
And in fact, P5 includes SMRs in mid 2032.
I believe about 300 megawatts was selected in mid 2032, yes.
And you also noted that we can come back in 2024 and we can check and adjust these assumptions, correct?
Yes.
All right. And you agreed, or would you agree that the pre-development activities like obtaining an early site permit has value for customers because it is technology agnostic?
Mr. Metz might be better to talk about the near-term development activities.
So in listed in my testimony is that we couldn't evaluate the exact actions that Duke wanted to take, but for understanding if you wanted to accomplish an aggressive goal to 2032, it was not unreasonable to move forward with those development activities.
Okay, thank you. And so, but the question I asked was, does an early site permit have value for customers? If the companies were to obtain one for new nuclear?
If we set an aggressive schedule, I believe that a early site permit, just an isolation of all the other factors that we need to consider, would be a required step to move forward to meet that aggressive timeline.
Thank you.
But I'd also just to add to that, in the 2024 and 2026 proceedings, there'll be many updates and many uncertainties resolved. And, if SMRs become infeasible, if the upcoming, expected nuclear renaissance fails like it did in 2000, an early site permit at that point would not provide value to ratepayers. So I think there's risks here, but, whether or not it will eventually provide value to ratepayers is really determinative on how the future plays out in terms of SMRs.
I believe this is also centric because the models continue to economically select these resources in 2032. As soon as they are available, they are being selected.
Thank you. And Mr. Thomas, did I understand your testimony yesterday to be that not performing pre-development activity could potentially sabotage efforts to be prepared for the resource in a particular year?
I think that when you talk about long lead time items, then I don't know if I use the word sabotage, but I think that you increase your execution risk if you wait on performing the actions that are within your control.
Okay. Would you accept subject to check? You did say sabotage.
If I did subject to check, yes. But I just want to caveat that the pre-development activities should be reasonable and within scope and comply with kind of the resource needs as they're identified, right? If Duke started building a reactor vessel, I think that would be preemptive, right? But some studies, better understanding of the technology and the costs that could be incurred, those types of activities I think are reasonable on a long-term time frame.
Public staff witness Boswell at page 9 does not recommend approval of the nuclear project development costs. Is that correct?
I don't have her testimony in front, but I'm sure you can ask her those questions, but subject to check, yes.
Okay. So if the company does not pursue the near-term development activities for new nuclear, doesn't it mean that we would be sabotaging new nuclear being available in 2032?
Sorry, so it is my understanding that Duke did not come in and seek cost recovery for these activities. They were merely laying out a plan, and that was me and Mr. Thomas's review was we're looking at what steps would be needed for that plan, or our discussion review did not center on cost recovery.
Yeah, I think if you have a copy of Ms. Boswell's testimony, I'd like to take a look back. I think that she was addressing more the cost recovery and deferral and where Mr. Metz was discussing more the activities that might be prudent.
You, I will get that paper copy for you.
Thank you. I apologize for not having this. Didn't know I'd be asked cost recovery questions. But. Nine.
So it is page 9.
Yeah, you're talking about page 9. So
I'm sorry, can you repeat the question?
Yes. Public staff witness Boswell at page 9 states that the public staff, it's line 3, does not have the information necessary to determine which initial project development costs might be eligible for special treatment under North Carolina General Statute section 62-110.7 and does not recommend approval of any nuclear project development costs at this time. So what I'm trying to understand is if you gentlemen believe it is reasonable, the SMRs have reasonable development costs. It's reasonable to expect them to be available in mid-2032. It could sabotage them being available if the company doesn't pursue near-term development activities. How do we reconcile that position with Ms. Boswell's position that the public staff's not recommending approval of any project development costs at this time? Is it simply just whether we're asking for cost recovery? I'm just trying to understand that distinction.
And I would object to this. I think these questions are more properly directed towards Ms. Boswell.
All right, I'm going to overrule the objection. I'll ask the panel to respond, recognizing that they're being asked about Ms. Boswell's testimony and anticipate Ms. Boswell being asked the same question.
Chair Mitchell, I might add an additional objection. I believe council previously objected numerous times to the use of subjective phrases. I think that witness Thomas has previously indicated his lack of belief that he used the word sabotage, accepted it subject to check. So I think she hasn't provided any context for what the word sabotage means in her question. So I think it's a vague question.
Okay, and I'm going to overrule the objection. Go ahead.
So again, deferring to Ms. Boswell to represent her testimony, but making the linkage between the two, it is more centric to cost recovery. Emphasis. Public staff does not have the information. That is from Ms. Boswell's testimony. When you look over on page 26, starting at line 10, or I'll start with the question, are you disputing the cost and required activities that Duke has stated? No, but I do not have the means to measure or evaluate Duke's listed activities. So again, for purposes of modeling, that we said, okay, yes, if you want to meet an advanced goal, that is more likely than not that you would probably have to do these types of activities. But however, as Ms. Boswell was pointing out too, if you want cost recovery, a more detailed analysis and review, as well as multiple other factors, and Ms. Boswell can elaborate to, also has to be considered.
And if I could just elaborate, that theme is throughout our entire testimony. We recommend addition of battery storage in the near-term action plan. We recommend, procurement of solar plus storage. We recommend approval of, we're moving forward on certain red zone expansion plans as part of the goals to meet 951. But in no way, we continually make clear that these decisions on moving forward with certain activities do not constitute approval of cost recovery. This is not a cost recovery proceeding. And this would be appropriately addressed in a general rate case, a multi-year rate plan, or other cost recovery proceeding where the appropriate investigation would take place on prudence and reasonableness.
Well, thank you for that distinction. I guess my question is the development setting aside cost recovery, the development activities for new nuclear that are laid out in the long lead time panel direct testimony. Do you happen to have that copy with you by any chance? And I could get you.
I do not have it in front of me. Should have brought more binders.
Binder overload. Permission to approach. Oh, thank you. Thank you, counsel. So I'm looking at page 32 of the long lead time panel direct testimony. It's table 2.
So page 32?
Yes, sir. Are you there?
Yes.
So there on page 32 at table 2, there are new nuclear near-term development activities. Do you see that?
Yes, and that matches the table that I listed on page 26 of my testimony.
And my question is, are those near-term development activities the types of activities that would enable the companies to be able to have SMRs available in 2032?
Yes, based upon my experience in the nuclear industry, these would be steps to move forward with that process. But it's like I try to identify my testimony, again, for illustrative purposes, looking at 2022 of $5 million. I can't tell this commission whether it should be $300,000 or $15 million. I think that's what we're trying to highlight in my testimony. I didn't have a means in this case to evaluate what actions and what should roll up into those total costs.
But the activities themselves are reasonable.
Yes.
And the activities are necessary, wouldn't you say, to be able to ensure that if we come back in 2024 or 2026 and check and adjust and need SMRs in 2032, we should get started on those activities after the commission order here, correct?
I think it's my testimony that if you want to meet if the commission deems that they want SMR technologies for 2032, which is an aggressive schedule, these are actions and not limited to that would need to take place.
Thank you. Turning to an additional piece of your testimony yesterday, Mr. Thomas, I believe you said you had looked at some IRPs from other utilities and they also had SMRs available in the early 2030s. Did I understand that correctly?
Yes, there were some. I don't recall the exact dates where they were selected or implemented, but some IRPs did not have it at all. Some IRPs had them but were not selected, and a smaller subset of that had them and had them selected.
Was one of those IRPs you reviewed Virginia Electric and Power Company's 2022 IRP update?
Yes.
That was just filed September 1 of this year?
Yes.
Okay. I have an exhibit to hand out. And Chair Mitchell, there's some handwritten notes at the top only because this was meant to be used on a different panel, and we will correct those and put them properly when we file them in the docket.
Okay.
But may we have this marked DEC, DEP, Public Staff Panel 1, Direct Cross-Examination Exhibit 1.
I think we're at 3, right?
Oh, my apologies.
Let's
3.
go 3. And so just for consistency, let's say Duke Energy Public Staff Panel 1, Direct Cross-Examination Exhibit 3.
Thank you. Gentlemen, do you have that Exhibit 3 in front of you?
Yes.
Yes.
And it is just an excerpt of a much larger document, but the cover page is the Virginia Electric and Power Company 2022 update to their 2020 Integrated Resource Plan. Is that right?
Yes.
And it was filed at this commission in docket number E-100 sub 182 on September 1st, 2022.
Subject to check. Yes, I believe that's the document.
Thank you. And so it's the second page is only an excerpt. It's page 7, and it's the section 1.2.2 small modular reactors.
Yes, this discusses, particularly the second to last paragraph discusses how they were included in the model. But I'll note this page doesn't discuss what was selected. But yes, these are the assumptions that were put into the model.
Okay, thank you. And then the second to last paragraph states that based on the status of SMR development, the company anticipates SMRs could be a feasible supply side resource as soon as the early 2030s. You see that?
Yes.
And then the last sentence of the page says, based on updated capital, operating, and maintenance costs, continued progress of licensing timelines and new policy initiatives or legislative changes, it is conceivable that the deployment of SMRs could be further accelerated by the company, with the first SMR being placed in service within a decade. Do you see that?
Yes, and I also note that this, to my knowledge, this IRP from Dominion does not request approval of any development costs or accounting deferral or any special treatment related to the costs of development that they appear to be already engaged in.
Fair enough. But that is an example of an IRP that you have reviewed that had SMRs coming in service in the early 2030s.
They were selectable in the early 2030s, yes. I don't recall off the top of my head when the resource was first selected, but I do know some alternative plans did select SMRs.
Thank you.
But I don't know in what year.
Thank you. Let's move to offshore wind, if we could. And starting with you, Mr. Metz, in your testimony, you testified that offshore wind development times are 10 years at a minimum from lease acquisition to in-service
Can
date.
you give him a page number, please?
Of course, page 24.
I'm on page 24.
Do you see there at the top of page 24 the amount of time that you indicate offshore wind, the offshore wind development time from the time of lease acquisition, that it's a minimum of 10 years?
I don't believe I did not clarify lease acquisition. Offshore wind development in the United States, the scale proposed by Duke in the carbon plan is nascent and expected to take approximately a decade at a minimum to achieve commercial operation.
Okay, a decade at a minimum.
If I could just add to that, I'll note that the development of these leases is also an extensive process for BOEM when they're even before they put the lease up for auction. So and there's a lot of work that goes into even defining those leases, getting them eligible for sale before even any bids are received.
Thank you for that clarification. So, Mr. Metz, staying on that page, you recommend reevaluating the need for offshore wind in the 2024 carbon plan?
That is correct.
Okay, so let's take ourselves to the 2024 carbon plan, and we're reevaluating that need. If it takes 10 years at a minimum to develop an offshore wind facility, wouldn't we be saying that the earliest time offshore wind would be available for North Carolina customers is 2034?
Absolutely not.
And why is that so?
Because Duke Energy Wind Renewables, assuming as the Carolina Long Bay, could be continuing the advancements of their project. To assume that a project's ecstatic and does not move, I can't speculate to what reason they would be doing that. That's their risk they took when they got the lease.
And I'd also add that there's 3 lease areas off the coast of North Carolina, and I don't expect that Avangrid or Total Energies are going to make no efforts to develop their lease areas between now and the 2024 carbon plan. I have no reason to believe that they would just do nothing.
Okay, so I guess the possibility then is they could be available sooner than 2034 if we wait until 2024 to make a decision on pursuing development activities. Fair enough?
Could you restate that question?
Sure. My original question was, if we wait till 2024 to start pursuing, meaning Duke regulated companies, start pursuing development activities on offshore wind, doesn't that mean with a 10-year development time that offshore wind won't be available until 2034? My understanding was a resounding no to that question. So then my question is, these other leases could be developed by either Duke Energy Renewables Wind or Avangrid or Total Energies, but that is not subject to the control of this commission or subject to the control of the regulated Duke entities, correct?
Yes, that's correct. I think those are three separate unregulated entities that are developing three separate lease areas according to their own business plans and their financial analysis. And the commission does not necessarily control what those companies do. And I won't speak for Mr. Metz, he can elaborate, but I don't think that we've come out in this. We've testified just yesterday that the 2024 carbon plan should, it could benefit from a more detailed analysis specifically of the three separate lease areas and how they compare and what is the best option for ratepayers. And I think that we all recognize that at least in SP5, offshore wind is still selected in the late 2040s or in the early 2040s. And I think what Mr. Metz is really recommending against is we don't think the commission should approve Duke Energy Progress to spend $155 million to acquire a lease and spend another $156 million in developing some of these resources for a resource that may not be needed until 2040. Particularly considering that a lot of the development work, particularly with relation to the lease itself, can be done by entities that are not Duke Energy Progress, and that risk can be put on entities that are not, cannot receive rates recovered through ratepayers. I think that would be less risk for the ratepayers in general, and I think it supports the check and adjust plan, and I think it helps ratepayers. Helps this commission give an opportunity to evaluate all three lease areas in future carbon plan proceedings and determine which is in the best interest of ratepayers.
And when you use the word balance again, is when you look at the entire carbon plan and you look at the upgrades and projects that are all being presented, we are also trying to balance those costs to the extent that we're going to do expansive transmission upgrades as listed in the red zone upgrade. That's one factor to consider. To move forward with SMR deployment, those are costs that we're also potentially going to move forward with it. To move forward with the uncertainties with Bad Creek Hydro, to move forward with all these other technologies, how we looked at this is these projects can move forward under unregulated business practice that they see fit. But yet here is another $300 million bucket, if you would, for costs. We just don't think it is appropriate at this time for the regulated utilities, in particular Duke Energy Progress customers or Duke Energy Carolinas, that we should move forward with this. The model suggested with the model enhancements that this isn't needed till the 2040s. There's time to wait, and that is a value.
And when you say the model selected in 2040, didn't Portfolio 1 and Portfolio 2 pick offshore wind economically in the 2030 and 31 timeframes?
I want to turn to Mr. Thomas a little bit to explain maybe the not extreme, but differences with the SP5 model and where we believe that is an enhancement.
Yeah.
And I appreciate that. Is it possible to answer whether P1 and P2 picked offshore wind economically in the 2030 and 2031 timeframes first?
There were blocks of offshore wind economically selected in those portfolios, which we found to have some unreasonable modeling assumptions.
Okay, thank you. So going back to the notion that the three unregulated or the three entities that are not regulated by this commission would continue to develop those leases, and we could possibly meet a 2030 or 2032 date for offshore wind. Are you familiar with the Avangrid testimony that in order to make those dates, meaning the 2030 date, they would need an off-taker for their agreement, for their lease?
Subject to check.
Okay. And basically we would, if this commission does not approve the decision to incur the development activities for offshore wind, aren't we subject to whatever these three unregulated entities want to do on their own time frame and at their own risk?
Well, the short answer would be yes, but however, when looking at the carbon plan, from a modeling standpoint, these projects were not economically selected in SP5 until way in the planning horizon into the 2040s.
Okay, fair enough. A slightly different sort of area of inquiry with regard to offshore wind. I believe, do you recall the exchange yesterday with Mr. Smith for Avangrid regarding whether a future study or future due diligence for offshore wind is needed?
Yes,
Okay. And the point of that future study or due diligence would be to find a least cost option under House Bill 951, correct?
yes.
Okay. Mr. Thomas, I note at page 34, you note that there is no guarantee that the Kitty Hawk lease can be secured from Avangrid because utilities in Virginia also have clean energy goals, correct?
Yes, that is what my testimony says.
Okay. Can you explain a little bit more about what you mean about no guarantees?
I mean, Avangrid is a company that's seeking to develop and sell the output of their offshore wind facility, and they may sell it to Duke if the terms and arrangements there are reasonable. They may sell it to an entity in PJM. They may sell into the market in PJM. It's really up to them, and the commission or Duke has control over what they do.
And are you familiar with the Kitty Hawk lease, that it's been recently split into a Kitty Hawk North and Kitty Hawk South parcel?
I believe so.
Okay. And the Kitty Hawk North parcel is scheduled to interconnect into Virginia Beach, Virginia.
I haven't seen that interconnection study, but subject to check.
Okay. And then the Kitty Hawk South parcel could go to Virginia Beach or also could come down to North Carolina counties. Would you accept that subject to check?
Yeah, it's my understanding that they have not submitted an interconnection request.
Okay. But in terms of the splitting of the lease at BOEM, the Bureau of Ocean Energy Management, that south lease can interconnect into Virginia or down into North Carolina.
Yeah, I think that's reasonable. Yeah.
Okay. So to your point of you can't guarantee that it would be available to Duke, it's possible that entire Kitty Hawk lease could be interconnected into Virginia and PJM, correct?
Yes, it's possible.
And Avangrid as a, commercial enterprise, they would seek to develop that lease to its highest potential, correct?
Yes, and I think, sitting where we are right now, there's 3 lease areas off the coast, North Carolina. In 10 years, there may be more. BOEM may lease more areas, right? So there's a lot of offshore wind plans I know in the pipeline and significant expansion of offshore wind capacity in the U.S. So, pardon me if I'm getting ahead of you there, but I think that thinking the only 3 options are these 3 leases is, that may change over time as well.
But as we said today, there's 3.
Yes.
And in fact, there's 2.5 because Kitty Hawk is really split into North and South, and only South can come down to North Carolina.
There's 3 distinct lease plots that could come into North Carolina.
Okay.
And it's not clear, I can't speculate whether Avangrid, where they're at in the construction process, if they started even laying the undersea cable, or whether or not they can redirect or re-request a new interconnection study at a different point. And I do not know the ramifications of what that means into their SAP or potential COP either.
Okay. Are you aware that both the Kitty Hawk North and Kitty Hawk South parcels are still pending BOEM review for their COP, construction operations plan?
That is my understanding, yes.
And until you get a record of decision from BOEM, you can't proceed with construction.
That is my understanding, yes.
So they can't be constructing yet on Kitty Hawk.
Yes.
Fair? Okay, thank you. So Mr. Thomas, back to you. In yesterday's inquiry with Mr. Smith, there was discussion of a study or a more due diligence. And I believe you said, and thanks to YouTube, I can verify, but that's okay. I believe you said you require sufficient information to evaluate potential options, and the more information, the better. Does that sound about right to what you said yesterday?
Yeah, it sounds about right.
Okay, so more information is better in this context, correct?
Yes, but I think just to clarify, I think I was mostly just talking about Mr. Smith's suggestion about a study that could take place between now and the 2024 update, and how having additional information specifically on the characteristics and wind potential that's available at each site, how many turbines might be installed, or what the wind speeds might be and the net capacity factor, so that a relative comparison between the 3 sites could be used. I believe I was referring to that particular discussion and line of questioning.
Okay, thank you. I'm going to hand out an exhibit.
Sure. Thank you.
And again, Chair Mitchell, these were marked for a different panel, but may we have it marked Duke Energy, Public Staff, Panel 1, Direct, Cross-Examination, Exhibit 4?
All right, the document will be marked for identification. Duke Energy Public Staff Public Staff Panel 1 Direct Cross-Examination Exhibit 4.
Mr. Thomas and Mr. Metz, I've handed out Duke Energy Public Staff Panel 1 Direct Cross-Examination Exhibit 4. Does that look familiar to you all?
Yes, I recall this data request or
Okay.
response.
Was it propounded by you by any chance?
Yes, I believe I worked on this data request.
Okay. And so this is Avangrid Renewables' response to Public Staff's first set, number 1, in this proceeding. And I'll give you a second to review it and just let me know when you're ready to roll.
Yes. Go ahead.
Thank you. So just to very briefly paraphrase what the request is, the public staff is asking Avangrid for the estimated levelized cost of energy for an offshore wind project in the Kitty Hawk region. Subpart A is asking for a minimum power purchase price that would meet Avangrid's internal rate of return. And subpart B is asking for a sale price based on a $1 per kilowatt basis, a minimum $1 per kilowatt basis sale price, correct?
Yes.
Okay, so if we follow up on our theme that the more information is better, the public staff tried to get more information out of Avangrid. Did you not, on a PPA price or a sale price for the Kitty Hawk lease?
Yes, I would try to get this information, but maybe it was a bit ambitious. I think we got good information here, but recognize that the objection to the data request, and we did not seek a motion to compel.
And for context, this was to enhance the modeling inputs or compare and contrast the modeling inputs and make any adjustments as needed.
Thank you. So just to, not to belabor it, but there was an objection that it was confidential proprietary information, and you made it clear that the staff did not seek a motion to compel. So just under the objection on that first page, right in the middle of the paragraph, Avangrid says, while Avangrid can share certain information with the public staff to help further its analysis of these issues, Avangrid is unable to share full LCOE or power purchase agreement rates without a formal structure. And then it goes on to explain why. Fair enough?
Yes.
Okay, so they didn't share a PPA price with the staff. Turning to page 2, at the end of the top paragraph, Avangrid says, if the commission were to design and implement such a process, for example, through a third-party study of owner-provided inputs as recommended in Avangrid Renewables limited comments or an RFP, Avangrid Renewables would look forward to sharing any and all input information requested with the commission and the public staff. You see that?
Yes.
Okay. And then under PPA price, which is at the bottom of that page, going on to the next page, the last sentence of the top paragraph, Avangrid states, as a result, while the company appreciates the purpose of the staff's question to improve price discovery for offshore wind, Avangrid Renewable cannot reasonably provide a PPA price at this time.
Oh, yeah. Yes, I see that sentence.
Okay, so no PPA price was provided, even confidentially. And then going to the last page on terms of potential sale, nowhere in those last 2 paragraphs does Avangrid give a $1 per kilowatt price for a potential sale, correct?
Not of their plot. No, they provide some regional price trends, but no, there's no price given for their plot.
Okay, so no price given for a PPA, no price given for the sale. There is a confidentiality agreement in this proceeding, correct?
Not between us and Avangrid.
But between the parties in general, there are confidentiality protections available, correct?
Yeah, I'm aware. We don't sign those.
Right. You don't have to, but the rest of us do.
Yes.
Okay, thank you. Fair enough. So my question is, I know there's discussion of a third-party study, future due diligence, where we have to believe that it will be the right environment where Avangrid would give their proprietary third-party information. And my question to you all is, what would be different in that proceeding that we don't have here today?
Objection. I think questions about confidentiality are more geared towards the legal proceedings and not something that our witnesses can answer.
And Chair Mitchell, I'm not asking about confidentiality protections. I'm actually asking about process. It appears that staff believes further study is needed, maybe further due diligence. And I'm asking, what would that look like in a future proceeding that is different than what we have right here?
Okay, I'll overrule the objection with that clarification and allow the question to proceed.
Chair, I'd just like to join the objection as far as the question in the data request, requesting information that was subject to a confidentiality. As such, Avangrid responded appropriately, and so that's why it was not applied to a normal proceeding, not after confidentiality.
I'm going to continue to overrule the objection. As I understand, the question is focused on a process involving confidential information. I'll allow the witness to answer the question.
Could you just restate your question again?
Of course. So my question is, Avangrid's position is that further a third-party study is necessary. And I would presume that that process has some adequate confidentiality provisions. But this process here had confidentiality provisions. And I'm asking what from the public staff's point of view would be different about that study other than it would be later on?
Sure. So yeah,
what's happening right now?
Happy to address that. So first of all, I just wanted to kind of level set that the model that Duke used that was selecting these offshore wind resources. This is a generic, essentially a generic wind resource using the internally derived costs and a capacity factor that was essentially a blend of estimated capacity factors in Carolina Long Bay and in Kitty Hawk. To my knowledge, there is no lease area that has that blended capacity factor. It was a generic resource, and it was attempting simply to, identify whether or not offshore wind as a technology would be part of the least cost solution. And I think if the commission were to order, some sort of third-party study that could receive information from Avangrid, from Total Energies, and from Duke Energy Renewables Wind, the three lease owners in the area, related to key inputs such as capacity factor and output profiles, lease cost, potential network or estimated network upgrades based upon studies that we've seen, public policy requests, and other information that's confidential. Put all that together and then actually come up with not only from that study what could be the least cost, but also information that could conceivably go into the 2024 carbon plan. I think I said yesterday that normally resources are not site-specific in an IRP capacity expansion model, but for the purposes of offshore wind, when you only have 3 potential resources, it could be reasonable to separately model them and see which ones are selected, right? You might have a less transmission costs associated with one, but the other one has a better capacity factor. There's more outages associated with one because of hurricane risk, or there's all these different functions and differences that could differentiate those 3 resources in the model that I think would be important to inform the 2024 carbon plan. Because what I don't want is to select a generic 800 megawatt block resource that may not reflect the actual characteristics of Carolina Long Bay, and then have the commission approve the purchase and transfer of the Carolina Long Bay to DEP, knowing that the capacity factor used in the model is a blend of both Carolina Long Bay and Kitty Hawk, which is likely above what Carolina Long Bay, being the less productive resource, will ever achieve, right? So I think it's important to provide some differentiation there and to not make these expansive radial upgrades. We can study things. I mean, yes, it costs money to perform a transmission study, but it costs a lot less than to transfer the lease, perform preliminary transmission upgrades, and then find out that the capacity factors that were put into the model are an overestimation of what this Carolina Long Bay will ever achieve. And so I think, given the SB5, which made some substantial modeling changes, and I can't tell you the reason why offshore wind was delayed by 10 years, but I have a feeling, my experience tends to suggest that it's probably because the increased adoption of solar plus storage and the better dispatching permitted by that modeling decision. And so I think it's important that if we can run sensitivities in 2024 that use that advanced modeling techniques and dispatch of storage, and we're still seeing 2040s, that gives us time to evaluate all three sources and still get them in service at or before the date that they're called for in the plan. I think it's very important to just make that distinction, that basing the $300+ million of expenditures by Duke based upon the Encompass models that they used, I don't think that's appropriate at this time.
But if the commission were to order such a study, the commission doesn't have jurisdiction over any of these three commercial enterprises, correct?
No, but I'm sure Duke Energy Progress and Duke Energy Renewables Wind have a working relationship and could enter into a non-disclosure agreement to exchange important information that would help inform the Carolina Long Bay lease evaluation.
Or secondly, this could be optional. I mean, the commission can say, all right, if you want to come forth to the study, come forth. And if no one shows up, then I guess we get our answer.
So if no one shows up, no offshore wind for North Carolina?
If no one shows up, to me, that would demonstrate that those projects were not serious or want to potentially sell their output to North Carolina.
Okay.
I'll just add to that. I think we're in a unique situation that there's three independent companies who own three separate lease areas. And as far as offshore, as far as onboarding and bringing those onto a particular balancing authority, I think Duke Energy Progress is uniquely positioned to pick one of the three, the best cost for ratepayers. And there's a bit of as far as offshore wind goes, there's a bit of a competitive market there. I know it's only three, but it's certainly better than just one. And I think it would not be appropriate to just simply pick a winner, Carolina Long Bay, owned by Duke Energy Renewables Wind, at this point in time, particularly given the substantial delay in offshore wind that's afforded by SB5 and perhaps a bit more optimal deployment of battery storage resources and other renewables.
But this commission could not compel any of the other entities, Total Energies or Avangrid, to sell their lease to Duke Energy Progress, correct?
No, of course not. But I think those companies have a vested interest in selling to someone and participating in a study to have their site more fully evaluated, have their investment more fully evaluated by this commission. Yes, the commission can't order, that this be a PPA be entered into or an asset transfer agreement be entered into with another company, but certainly they could, based on the results of a study, order Duke to open up a competitive procurement for offshore wind resources that would be open to those three leaseholders. And then through an independent administrator or evaluator, DEP could pick the most competitive of those three leases, regardless of who owns it and whether it's a regulated affiliate or not. And I think that's the important concept here, is we are just trying to make sure that ratepayers get the best bang for their buck in terms of offshore wind. It can be an expensive resource, but it does provide benefits in terms of its output profile. And so I think it's important to make sure that ratepayers, if this is a cost-effective resource and part of the least cost plan, that ratepayers are getting the best bang for their buck from these three separate entities that could potentially compete to provide that output.
I have no further questions.
All right, redirect.
I just have one question, then I'll hand it over to my co-counsel. Mr. Thomas, you were discussing with CPSA's counsel yesterday about procurement targets and SB5 versus SP or just P1. And when weighing the amount of megawatts to procure each year and in total, when you set a target number for an RFP, is it not important to balance that target number to ensure that you receive enough bids to make the bid process competitive and try to seek the lowest amount of the lowest bids. But also balance that with the ability to not procure so many megawatts that that the bids know that they're going to win, essentially. Can you speak to that a little bit?
Yeah, I think, I think I've discussed a little bit, and I was pointing out that, that bids are conceivably in a competitive procurement. Everyone's bidding in, with their sharpest pencils, the best price that they can offer. But that's going to be a range of potential offerings based upon the price. And I think we've seen, for example, CPRE, the Competitive Procurement of Renewable Energy Program, that had an avoided cost cap. But if it didn't, such as the 2022 solar RFP, tranche 3 of the CPRE was for 600 megawatts, and it had, I don't believe this, yeah, it had 596 bid in. If there had been no avoided cost cap, there'd be no reason to continue. Every bidder that bid in would get a PPA at their bid in price. The target has been assessed, and there's less that bids in. I think that's an extreme example here, and I recognize that 2022 solar procurement volume is fairly robust relative to the targets being discussed by some parties. But I think that the commission does have to be aware that the higher that target is, not only do you run into execution risk, but you start to get in those high level bids. And if there's a pretty decent spread, you can start to get in very high cost PPAs, high cost asset transfers, which can elevate risks and costs to ratepayers.
I think most of my questions will be for Mr. Thomas. So first, Mr. Thomas, yesterday, Council for Tech Customers asked you several questions related to difficulties with Duke's modeling inputs. Were there any other challenges related to validating Duke's assumptions and inputs that you experienced?
Yes, thanks for asking. I think that the modeling part of it is one side of it, but I think Duke performed a bit of additional analysis both on the front end and the back end that made both modifying their inputs challenging and validating their outputs challenging. For example, Encompass has a field in its modeling inputs that allow you to specify capital costs in dollars or in dollars per kW. Those are the figures that all of us are very familiar with. And then you can put other fields into that, such as debt to equity ratio, AFDC percent, AFDUC percent, and other financial inputs that will help convert that capital cost in dollars per kW into a levelized charge, which is what the model optimizes over. Duke chose to do that whole process outside of the model using proprietary tool or using their own calculations and own spreadsheets. It's much the same process, but simply they did that outside the model. So it made it difficult for folks to take the supply side data manual and then check it against the modeling inputs to kind of validate that there's a clear path from Duke's capital cost estimates to what was actually used in the model. Some interveners discussed this as well. So that made it challenging, and I hope that in future carbon plans, Duke, adjust this in comments a bit, but we'd like to see them, convert to the Encompass system, the native Encompass system, make that easier. And that flows through to the outputs. Duke did not calculate the revenue requirement for capital investments based upon the model. They took the capacity that was built and then they plugged that into an external spreadsheet that would then calculate the actual costs of these resources, again, based upon this real levelized fixed charge calculation that's external to the model. And I think that I don't believe that those materially would have affected the results of the model, but it certainly made it harder for us and for other interveners doing modeling to validate both inputs and output calculations for PVR, for present value of revenue requirements.
Thank you. And then turning to questions from Council for Kingfisher. Yesterday, you were asked several questions related to the utility ownership requirement in House Bill 951. Could you clarify the public staff's position regarding utility ownership of resources and PPAs under the carbon plan?
Yes, I think I may have misspoke there, but consistent with our comments on September 9th, should the commission decide that a PPA is a resource that can be procured, through a PPA, under the carbon plan, we would not support recovery in base rates and a rate of return, or we'd at least have to see that evaluation, right, to compare a PPA versus a utility-owned resource to find out what's in the best interest of customers.
And counsel for CPSA asked you if the near-term action plan should be consistent across all portfolios, and you indicated that your near-term action plan recommended in your testimony primarily supported SP5. Can you explain why you put so much emphasis on portfolio 5?
Yeah, so I think, and I think I addressed this slightly, but P1 through P4, I would view those kind of almost entirely separately from SP5 and SP6. And I think there were very fundamental changes, not only to things like gas supply and dispatch of units, but also looking at, removing, cumulative caps on energy storage that were put in place, allowing Encompass to economically dispatch the energy storage component of solar plus storage resources. I think those are fairly fundamental changes, and some of that's reflected in increased model runtimes. But I think that those are important changes because that's how you would dispatch storage, right? You dispatch it however you want it. And it's clear to me that these changes resulted in, delays in offshore wind, for example, that could result in allowing a more thorough study and more information. So that's why we kind of aligned our near-term action plan, not to try to average out over P1 through P4 and our SP5, but really to focus on SP5 as, with more appropriate modeling assumptions that validated some of these resource needs.
And Mr. Thomas, counsel for CCBA asked you about resources that are not yet available, including those for which there is currently no supply chain, such as SMRs. And you've testified about how assumptions can change over time, including the kinds of resources or prices that might be available to us in the future. So Chair Mitchell, at this time, I would like to hand out some documents. I'm not going to ask for them to be moved into the record as exhibits, but I'll ask that judicial notice be taken of these. There are 2 documents. So the first document is, and I've put exhibit stamps on the top, but we can disregard those for the sake of time. The first document is titled Duke Power Annual Plan. It was filed in docket E-100 sub 102 on August 30th, 2004. And the second document is titled Progress Energy Carolinas Resource Plan, also filed in docket E-100 sub 102, and this was filed on September 1, 2004.
And the commission will take judicial notice of these 2 filings made with this commission.
Thank you. So, Mr. Thomas, first I will refer to the document that has Duke Energy stamped on the top left. And this is the Duke Power Annual Plan from September 1, 2004. And if you can turn to the top of page 3, can you tell me what the planning horizon is for this document?
Yes, the 2004 annual plan it's a 15-year horizon.
Thank you. And if you turn to page 30, could you read the highlighted language for me?
Sure. It says, with relation to supply side options selected for the expansion plan are subjected to an economic screening process to determine cost-effective supply side technologies. Duke evaluates conventional, demonstrated, and emerging technologies. The technologies with which pass a cost screen, a commercial availability screen, and a technical feasibility screen are considered viable supply side technologies.
Thank you. And if you turn to page 33, you'll see a chart there labeled Screening Evaluation of Generation Technologies. Can you tell me, looking at the last column, which technologies the company retained for economic screening?
Yes, a combustion turbine, a combined cycle, and three types or three types of supercritical, subcritical, and fluidized bed, circulating fluidized bed coal, and then a pump storage facility.
Thank you. And was wind included?
No,
Solar PV,
no,
battery storage?
no.
Okay. And then if you could turn to the second document, it's got the Progress Energy stamp on the top left. This is the Progress Energy Carolinas Resource Plan for September 1, 2004. Let's see. And if you could turn to page 2 and read the highlighted language.
Yes, Progress Energy Carolinas periodically assesses various generating technologies to ensure the projections for new resource additions capture new and emerging technologies over the planning horizon. This analysis involves a preliminary screening of the generation resource alternatives based on commercial availability, technical feasibility, and cost.
Thank you. And if you turn to page 9, this is the screening evaluation of generation technologies. And again, if you look at the last column, can you tell me which technologies the company retained for economic screening?
4 different types of combustion turbines and a combined cycle facility, and 3 different types of coal.
Did they include wind,
No,
solar PV?
no.
Okay.
And I would just note that I don't believe battery storage is even included in this.
Thank you. So looking back at the company's resource at Duke Power and Progress Energy's resource planning in 2004, what do these documents tell you about how assumptions, technologies, and costs can change over time?
Yeah, so I mean, we all know this, that technologies advance quickly. And I obviously 18 years ago, no one thought that solar and battery storage and wind would be playing such a pivotal role in this decarbonization effort. And I think that, one reason the public staff is kind of, a lot of interveners and Duke have talked about what's happening by 2050 and overly relying on particular supply chains for nuclear and the risk of doubling, certain capacities or relying on too much of, lithium ion battery storage. And I think this just, emphasizes that this near-term approach, looking at this is perhaps more important because we don't know in 18 years when we're doing the 2040 carbon plan and half of us are happily retired. And I think that's going to be very, it's going to be a whole different landscape and potentially even, have other technologies that are eliminated in Duke's current generation screening alternatives, right? They eliminate certain types of fuel cells or liquid air batteries. A lot of energy storage technologies are eliminated. Carbon capture and sequestration is eliminated based on current knowledge, right? So I think so much can change between now and 2035, 2040, that we can't even foresee, and hopefully new technologies will emerge and technologies not currently commercially available or economically viable will play a major role out beyond 2030, 2035, and into the future.
Thank you. I believe I only have one more question. Counsel for CPSA asked you a series of questions about meeting the interim target by 2030. What do you believe are the most important things for the commission to consider when adopting its final carbon plan?
The public staff, we believe the targets in HB 951 of 2030 is important, and we need to get there. But I think the commission also needs to consider, cost and execution risk, executability, and reliability as well. And 951, much like Senate Bill 3, which enacted the REPS mandates, provided the commission flexibility to determine, when these targets are met and to protect ratepayers from, undue risk, unreliable grid, or excessive costs. And I think the commission has to consider all of those part of that three-legged stool to make its decision on when what portfolio should be adopted and what interim compliance years should be met.
Thank you. That's all the redirect we have.
All right. Questions from commissioners. Commissioner Gladfelter.
Thank you, Madam Chair. Mr. Metz, you had a very lengthy exchange with Mr. Schauer that has taken care of a lot of the questions that I had, but I do have a couple of follow-ups on the same point, being the assumptions about incremental gas availability with firm transportation that are used in portfolio 5 and 6. And I know you were referring, I don't know if you still have it there in front of you, but when Mr. Sherrill was questioning you, he was making reference to the sort of summary table that's in the Duke Modeling and Near-Term Action Plan Panel Exhibit 1 that sort of lays out in tabular form the difference in assumptions between Duke's portfolios 1 through 4 and the public staff 5 and 6. Do you have access to that?
We're looking.
Okay. Yes. Well, doesn't look like that. It's page 3 of 29 in Exhibit 1. You know, I think I may be able to ask the question.
Is it rebuttal table 2 and rebuttal table 3?
No. Let me see if I can ask the question without you having to have the document in front of you. One of the parameters that you varied in portfolios 5 and 6 from what Duke had used, assumptions Duke had used in portfolios 1 through 4, related to backup fuel supply for future CCs and CTs. And Duke had assumed in portfolios 1 through 4 that any new CCs would be configured with low sulfur diesel backup, and that CTs would operate on low sulfur diesel for the month of January. In 5 and 6, you varied that assumption to assume that new CCs didn't have low sulfur diesel backup. That's a tongue twister for me, at least. And that the CTs would operate on low sulfur diesel for only 2 weeks in January. And my question, that's accurate, consistent with your recollection, even though you don't have the document.
Yes, sir.
My question to you is the reason for your variation in that assumption about the backup fuel source for the CCs and the CTs, is that derived from your assumption about the additional firm transportation zone 4 fuel availability as a result of the Southside Reliability Project? Or is there some other reason for varying that assumption?
That is in part. So I think it was one of the observations that we were trying to see is understanding these are peaking resources, notably combustion turbines during the month of January, that we do, from modeling purposes, we have a carbon cap for every given year. We were exploring, and Mr. Thomas can jump in here, we were exploring to say, well, if you run a combustion turbine for peaking purposes for the month of January on ultra low sulfur diesel, you'd be emitting much more carbon. And we said, okay, well, are we getting an artificial result that doesn't match how we've actually ran our system? So through past experience since I've been with the public staff, is like we have never ran, fortunately, knock on wood, that we've never had to run our entire combustion turbine fleet off ultra low sulfur diesel. So we would never actually see those carbon emissions. What we have seen, though, is that during notably the 2018 polar vortex, that it was not because of a fuel constraint on the system, but an economic decision that it was actually more cost effective to run the CTs or a part of the CTs off of that higher carbon emitting resource, at least for a week. So it was a little bit of art, for lack of a better word, for modeling purposes to say, we're going to make these assumptions because we think that more properly mimics system behaviors that we have occurred and what we should be planning for, Mr. Thomas.
Yeah, if I could just add, I mean, if the model had hourly natural gas prices, you wouldn't have to make these kind of assumptions, right? Because the model would economically dispatch between the two hourly model gas prices and hourly gas supply constraints. But it doesn't work like that. It has monthly gas supplies, and while the winter months are higher than other months, they still don't capture those peaks where the system is really strained and the polar vortex is coming through, and we're seeing gas at 20, 30, 40, a BTU. So I think that's kind of the assumption that we're making here. And We just thought that Duke overstated the amount of sulfur that they're going to use in the winter season. And so we wanted to dial that back a bit.
Based upon historical operations of the units.
Yes, sir.
The same, your answer was referring to the CTs. Would the answer be exactly the same for the new CCs that you're assuming that they don't require any to be run on low sulfur at any point because historically the CCs have not run on low sulfur?
That is correct. And I would defer to for Duke of how they run their system. I think it would be extremely challenging to run a 800 megawatt combined cycle on ultra low sulfur fuel 24/7. I can't even imagine logistics and the amount of trucks that would just be lined up.
And I'd also just, I didn't want to, they don't have the backup, but I believe the CCs do use ultra low sulfur diesel for startup. So in the model that they do still have that startup is a little bit different than full operation. So they still have to access that fuel like in the real world, but the startup uses a different type of fuel.
Well, thank you for the answer. It helps me understand why you made the assumptions you made, which is what my question's trying to probe. But I want to be sure I understand that you thought that assumption was valid, even though the assumption was going to apply to additional units on the system. Units not now or in the past history in operation on the system, incremental units. It was still safe to make the same assumption as you made about the operating characteristics of the existing units.
And then that in part pivots to when in reading the Williams Transco expansion project.
Okay.
Yes, we believed it was reasonable.
So you had a two-factor basis for that assumption.
Yes, sir. And to go on further, more detailed information behind it. I'll stop if you want me to.
No, I'll take the detail.
So, and part of that conversation was, well, you have and I don't mean any negativity towards this in terms of modeling, but you have the 1200 megawatt J-class combined cycle, which is going to use more natural gas. It's just a function of the size, but it's more efficient, and I get that. However, we also asked Duke, because we understand that there may be nuances in the modeling, we said, okay, include the slightly less efficient F-frame combined cycles that are only approximately 800 megawatts. So will the model jump between either 800 or 1200 if we did introduce these potential modeling constraints due to lack of fuel supply? For the model, it did not in this case. But that is something that we are also forward looking to say, yes, the model may have selected 1200 megawatts, but as time advances, we can scale that back down to potentially to 800 megawatts when we're looking at a CPCN if we have future concerns as we continue to evaluate potential lack of firm transportation supply, 365 service, or notably during the month of January. And I would like to Duke did do a good job of trying to pick up that sensitivity that the public staff has advocated for from the 2020 IRPs, that it was an appropriate first step to Duke to say, yes, public staff, we've heard your concerns. There is the possibility of lack of supply, and therefore the system will be constrained in January, so we are going to restrict it.
Thank you for that. Again, one more follow-up on this point. And this really is to any of the three of you. Are any of you familiar with the motion to intervene and comments and support filed by Piedmont Natural Gas Company in the FERC docket by Transco concerning the Southside Reliability Enhancement Project? It was filed on June 28th of this year. Have any of you reviewed that filing?
I have not.
I have not reviewed it. I'm cognizant of it, but I have not reviewed the filing.
Based on what you do know, are you aware that it's Piedmont's position that they support Transco's application because they have fully subscribed to 100% of the additional capacity that will be made available by the Southside Reliability Project?
And that is the horizontal line, and that specific topic is an active docket in Piedmont Natural Gas's annual review, which I believe I filed testimony in, and public staff witness Nader had filed testimony in.
So it's your understanding that Piedmont has only subscribed for the incremental capacity on the lateral line running over to the Albemarle Sound area, and not for any additional capacity that may come on the main line?
That is my understanding, yes.
if it is in fact the case that Piedmont is also subscribed to all the additional mainline path capacity, that's not consistent with your understanding, is it?
That is not consistent with my understanding. And a point that we're continuing to potentially evaluate here is the function of displacement. I don't know for certain at this point in time if Piedmont, and not speaking on behalf of Piedmont, but if we have this new natural gas supply system across that horizontal, that could mean theoretically that would be less gas need to be pulled off the main line, because it's just a different point of service to some. So there's a function of displacement that we're continuing to evaluate and look at. Or stated differently, that line could free up capacity on the main Transco line as Piedmont grows into its load over time, theoretically.
Again, though, you have not reviewed Piedmont's actual filing and what they say in their filing with the FERC.
I have not.
Okay. Then we'll stop with that questioning for you. I have a couple of just minor things I want to understand about your pre-filed testimony, just to be sure I know what's going on. Mr. Metz, again for you, on page 11 and 12, you have a footnote on page 11, but it really relates to, the footnote relates to the chart that's on page 12. It's an interesting sequence there. But in the footnote, you say you're still, at the time you file this, you're still reviewing the supplemental model inputs, including some unexpected outputs relating to natural gas combined cycle capacity factors. And then you refer to the chart. Have you completed that review and determined why you initially saw that unexpected output?
We have not completed that review. We're continuing to do continued model runs and explore that possibility. It's a minor observation. What piqued my interest was the relatively higher than expected capacity factor. That doesn't make it wrong. And to give context, let's just say eyeballing, it's approximately 78%. While we have achieved that annual capacity factor on distinct combined cycles across the plant, my expectation was it was going to be, for just looking at it based upon tribal knowledge, is it should have been closer to 70. So maybe 72. I mean, looking at it across a fleet level. So from a modeling standpoint, it just seemed a little bit high in that given year. So if it was high, does it mean something else would have to generate in real time? This could be a modeling artifact. This could be perfectly reasonable. It's just something that caught our attention that we're still continuing to evaluate.
Thank you for that. Let me ask you about the chart on page 12. Just again, I'm not sure I'm understanding exactly what I'm seeing on that chart. What talk to me about in the years 2022 through 2030, what I'm seeing there in the gap between the line on the capacity factor and then the bars for the production run. What am I looking at there? What is that gap telling me?
So the production run megawatt hours and that potential gap that's underlying it. Just trying to reorient myself back to the raw data coming into it. Mr. Thomas,
I think I can maybe speak to this a little bit. I'm not familiar with the exact numbers used here, but I would say this is likely, since we're looking at the bars, our number of gigawatt hours coming out, and then the capacity factor is the line. I think in those first years, that's kind of reflecting that there's no new CC capacity being built there. So I expect that this is likely a function of the fact that new CCs are coming in 29 and 2030, and that gap there is just representing kind of higher utilization of existing natural gas assets. And then once you bring those other ones on, it all kind of eases up.
Thank you. I needed you to help me make sense of the chart, and that's I think you've done that. I think you've answered the other questions already in examination by other councils, so that's all I have. Thank you.
Commissioner Duffley.
So I only have one question. It's for Mr. Williamson. I'm going to give you some airtime.
All right.
So if you could turn to page 40 of your testimony.
I'm there.
And so on lines 6 through 8, you testify the current annual residential DSM EE rider amounts are $57.24 per year for deck and $86.52 per year for DEP, including for low-income customers. And so my question is, do you know how these per year amounts compare for DSM EE residential customer charges in other states that have these programs? And I understand that there's some differentials in the programs and what's included and what's not included, but just your general sense, do you know how these amounts compare?
So Duke Energy in North Carolina and South Carolina have very well-developed EE portfolios compared to other states that they provide. I think in the EE rider, we get a list of the measures that they actually offer to customers within their programs, and it's in the roughly 500, 600 some odd different measures. The majority of them are for non-residential customers, but a good portion of them are for residential as well. But compared to other states, because of that volume of measure type offering, Duke Energy's EE rider, in my opinion, would be higher than other states. Noting that in South Carolina, I believe the rates are a little higher than North Carolina's EE rates. But South Carolina is the only state that I have off the top of my head as far as what their EE rider consists of. And I think that's just a function of the accounting.
Okay, and if I wanted to try to look and compare,
More appropriate now that we actually have a